In Melbourne town, where the suits all grind, there's a lawyer with a vision, one of a kind. He's the Aussie Overlaw'd. He'll fight for your rights, and he's got his own channel shining bright. From the courtroom to the web.
Seems more zoomed in than usual. It definitely is, because you can't see the photo from... You can't see the other photo. So, god damn it. There's going to be some hiccups today. I don't know why, but I went to log into Streamlabs, and all of a sudden it made me start everything from the start. So... I have no idea. Fingers crossed I can work some stuff out. There's low volume. Alright, hang on. Oh, wow. Yeah, it's dropped my input down to 60%. Hang on. Watch your ears. Okay, there we go. Mic's back up to 86%. Hopefully that's a little bit better. Glennis, I'm not doing too badly tonight. After missing most of the night's sleep last night, I went and did a full day of pretty much video recording and planning out and that sort of thing for Scarlett's channel, for Scarlett's Wonderland. And no, I didn't get much of a nap. So we're in for a wild ride, particularly because half of my things are missing. And I have no idea what to do here. I mean, I've got the news, which is fine, but I didn't check the... Oh, hang on. There we go. Why is that out of order? Hang on. I'm going to have to just move things around and deal with it as it comes. So, but anyway, what I was planning on doing tonight is obviously we had the Karen Reid motion to dismiss that was released a few days ago. The defense about the state, I should say, about... a day ago, 19 hours, I think it was posted most recently, lodged their opposition to the motion to dismiss. So what I want to do is start by going back, because I never actually watched the verdict on my channel. So, you gotta have a nanny nap today? Sorry to hear that. Oh, you got to have one. Ah, fair enough. I'm gonna go back, watch the verdict, because I never actually watched it here. We'll go through the motion to dismiss, and then I'm going to look at the state's opposition. So it's going to be a fairly... reading intensive stream, but I'm curious to see exactly what they had put in there and what the arguments are and that sort of thing. And I mean, look, now that we're at a fourth juror that's coming in saying that there's issues, I kind of have an issue with Bourne had to have paid off the judge and the prosecutors. I'm not so sure, Achiro. I think it was just a massive cock-up. I really do. I think someone tried to do something sneaky and underhanded, and it's cost them a trial, and it's been dismissed with prejudice. And someone that I genuinely believe should have faced jail time is now walking away scot-free. So, it is what it is. Unfortunately, it's a circumstance of the judicial system. It's how we protect innocents from being behind bars inadvertently. Is it two direct jurors and two friends of a friend of a friend? No clue. That's why I haven't had a chance to look too much into it, so that's why I'm here, because I've got crap to catch up on, basically, is what I'm saying. So, let's get stuck into it. Welcome to today's episode of To Be Advised. However, I'm going to play the regular opener. It's going to take some time for me to fix all this stuff up. That's really freaking annoying. How is that so far down the block? So the first thing I wanted to do, obviously, was go back to the verdict form, because really, that's long time since I've seen Chandler around. Is she still active? Chandler's mostly interacting on DUI Guy's channel. I mean, that's where she's been. That's where she is, and to be perfectly honest, I've been a bad friend. I haven't reached out and said, hey, do you want to come onto a show or anything like that? But she seems busy. I'm not going to begrudge her that. I mean, she and Larry were dealing with the Ballwood trial, and I think they're going to be doing some other things. Morrissey's a shit prosecutor. Well, I mean, look, let's face it. Most prosecutors with the last name Morrissey seem to be shit in most instances at this point. But I mean, let's have a look at this form, because this always really irked me, and I never actually gave a proper opinion on it. I mean, when you actually look at this, it's fairly straightforward to see exactly how and why you could have the jurors coming back saying, well, hang on, we decided that she wasn't guilty on charges 2 and 3, but we didn't return a unanimous verdict saying that she wasn't guilty on charge 2, because the form itself basically has not guilty at the top, and then it's got a list to check whether or not you're guilty as charged of offense 1, lesser included, and so involuntary manslaughter and motor vehicle homicide. I can understand why a jury would have looked at this form, returned it to the judge, and said, hey, we have some irreconcilable differences here. We believe we are genuinely hung on the basis of this form. In my professional opinion, this is a terrible form. Each of these should have had a guilty of this offense, not guilty of this offense, guilty of this offense, not guilty of this offense. Because we have to treat everybody as if they are in first grade. Everybody needs to have their hand held, and everything needs to be made very clear for everybody. So I can fully understand that after the fact, we've got 4 jurors coming out saying, yeah, no, we did come to a conclusion. Borden's 100% at fault for shooting 2 people, killing 1. Should have been convicted. His money wasn't helping, but the prosecutor's a moron. Yeah. Love to see Baldwin get the Trump treatment. Won't happen. No, that's alright, AP. You can run away. Legs 11. Hey, Dog Backwards, how are you? So, as I said, where are we? Where's the mistrial? Here we go.
Thank you. Be seated. Closing session.
22117 Commonwealth versus Karen Reed.
All right, the jury is at an impasse. So we'll bring them in.
Wait, what's that? So this is the form for only charge 2, is it? No, that form was for all 3 charges. Hang on. So for anyone that doesn't know, this is the verdict slip that was given to the jurors. This is what they were provided to check off and to say whether or not she was guilty of all 3 counts that were charged against her. They had the option of finding her not guilty. And this is the argument that... this is the... Wait, what? Oh, shit, it is too. Verdict slip defense too. Wait, what? I'm positive that's the verdict slip that was given to them for the 3 charges that were against her. hang on, where's the indictment? That's probably where this is coming from, because if there were multiple things that she was originally charged with as offences, and certain things were dropped, that would explain why offence 2 is still listed as murder. Give me a second. I just want to double check something. And what the fuck is all this? Why has Chrome changed as well? Was there some update to my computer or something? Hang on. Reddit, Karen Reed trial. Search indictment. Yeah, so that was the verdict slip. Oh god, I gotta go the whole way down through. Higgins discovery, Commonwealth's case, Gemma Cave's search history. This frustrates me. Just needs to say check everything you believe she's guilty of or none if not guilty. But in confusing lawyer language, still better than that. Yeah. I sent it. Thanks, Burr. What the hell? I can't open them. What is going on? What extensions have I got on? Audio output. Da, da, da. Dark reader, page markers on. That's fine. I got no issues with that. Super dark mode. I don't want super dark mode on. Interesting. Attic cats. No, fourth screen. Just makes it easier. Hey, Gun Club, how you doing? Even adding extra spaces after not guilty to delineate would have been helpful. Yeah, I'm not a fan of this verdict slip. Where are we? God damn! And see, this is what happens when things go sideways. Jimmy Cave search history. That's not what I want. Okay, unsealed documents. Defense. Sources denied. No. Hostile to dying cold. That was always great. All I want is the original charging sheet. You know, being out of the US makes it nice and difficult. The slip should come with a doctorate if you fill it out correctly. Oh, no shit. Okay, that changes things because that... That is not how I thought the verdict slip was set up originally. There you go, learn something new every day. This is why I actually need to pay attention to shit. Thank you, Burberrys, appreciate that. Did she kill him with a car while drunk? Well, that's what's alleged. So it was whether or not they found her not guilty. Well, I mean, in that case, if that's how it was in relation to that. Okay. All right. Anyway, let's go back to the declaration. Yes, we definitely know that it was snowing.
You guys for the jury?
And if you could keep, like, rustling of papers and crap away from the mic, that'd be great. Hello, dipstick. Completely forgot that I have to look at your face again. Look at Jackson's hair. Like, I can't comment, but still.
Court of the session, please be seated.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case.
And that's where, in my opinion, she fucked up. Because, and I'm gonna bring it up. Shit, where did it go? Crap, have I still got it open? I think I still got it open. Probably should have actually opened it in the first place now that I think about it. Where is... Oh, screw it, I'll just reopen my chat with Jeff because I sent it to him. Right, WhatsApp. From only one side. Yeah, so I can probably close all that. There it is. Massachusetts Criminal Procedure Rule 27. Which I already had up here. Okay. Procedure Rules 27 verdict. Several offences of the defendants. If two or more of the offences of the defendants are tried together, jury may consent, blah, blah, blah. Verdict is returned, but before the verdict is recorded, the jury may be polled in the discretion of the judge. Where was... Shit, where did it go? Though two or more offences or defendants tried together, the jury may consent to the judge at any time during the deliberations, return, or be required by the judge to return a verdict or verdicts with respect to the defendants or charges as to which the verdict has been reached. It was purely within her power to actually have them return the verdict on 1 and 3. She just decided she didn't want to. Now, don't get me wrong, people are going to say, well, it says may. Well, there's some case law on that. Judge may declare a mistrial as to any charges. Where are we? May in their discretion. Therefore, the jury may, in their discretion of the judge, resume deliberation. The judge may declare a mistrial as to any charges upon which the jury cannot agree to a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. As far as I'm concerned, the verdicts for counts 1 and 3 should have been entered and recorded. Where are we? Point B, subdivision. Subdivision permits a jury in multiple defendant or multiple offence cases with the consent of the court to return a verdict at any time during the deliberations with respect to the charges or defendants as to which a verdict has been reached. This rule also permits the court to require the return of such verdicts before the jury has reached a verdict as to all of the defendants or the charges. In either case, if the court directs the jury to continue its deliberations after rendering the verdicts under this subdivision. To the extent that this rule permits the jury to return such verdicts without having reached a decision on all charges of the defendants, it is consistent with the federal rules, the Court Rules of Criminal Procedure, Rule 535 C and D from 1974. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. However, it must first receive and record the verdicts which the jury can agree upon. So if the jurors that are coming out saying, yeah, we agreed. We said that it was unanimous. Charges 1 and 3 were out the window. She should have at least told them it was an option to find what they agreed upon and left the rest blank. So, ABA standards relating to trial juries, Rules of Criminal Procedure, Rule 541. Subdivision B does not prohibit retrial of those defendants to whom the jury is unable to reach a verdict. This is consistent with the federal criminal rules, which provides that in cases of multiple defendants, disagreement as to one or more defendants has no effect upon the verdict as to any other defendant, and such defendant may be retried without violating the protection of the double jeopardy clause. It's been long settled that jeopardy does not attach where the jury is discharged after an inability to reach a verdict. United States v. Perez and Thames v. the Commonwealth. It is within the discretion of the court to declare a mistrial where there is a manifest necessity. Unless such manifest necessity exists, a second prosecution will be barred by the double jeopardy clause. Since Perez, it has been held that where the jury has been unable to agree upon a verdict, the declaration of a mistrial is a classic example of manifest necessity. Is there much difference between Aussie law and overseas law? So up until a certain point, no. Australian law, obviously, jurisprudence for our case law and that sort of thing developed on its own from about 1900 onwards. When we cut ourselves off from the Privy Court, because it used to be that you could go through the state courts at the bottom level, work your way back up to the High Court of Australia, and then if you didn't like what the High Court said, you could actually apply to the Privy Council in England. We filed an act. Well, filed an act. We lodged an act. No, oh my God. We enacted an act that removed the ability to apply to the Privy Council for whatever else. Since then, Australian jurisprudence has branched off significantly where cases that have gone to the High Court have set their own thing across the board. In terms of anything prior to that, the common law is actually remarkably similar. We have the same concepts in contract law, in trust law, in criminal law, pretty much across the board, really. So, common law is common law regardless of country since it came from England back in the day. Yeah, except common law actually it was called common law at the time because it was judge-made law. It's not called common because it's common to to all the countries. It's common law because it is literally the law that is made by judges and therefore is made by the common folk, not by the legislature. England probably laughed their asses off when they had to do trials for Australia. Yeah, probably. Commonwealth stated they intend to retry her, but intent doesn't mean that they will. Well, I kind of think that with the shit that they're talking about, that it's going to happen. So, but surprisingly, that's why when people tell me to shut the fuck up about talking about American law, yeah, they can sit on it and rotate, basically. So, where are we? If you think back to Rittenhouse, which had a bazillion charges, they reached verdicts on many different days. I wonder if those 100 pages of instructions mentioned you can reach verdicts on some charges. Yeah, you more than likely would have been able to, Brandon. So, shit, where are we? Oh, hang on. Did I even open? Yeah, I opened the social stream chat, didn't I?
In May 2000.
No, you rack off. Don't need that. Strange. You know, I'm just going to close some of these things because I've got crap everywhere. That's what happens when I scramble to try and fix bloody Streamlabs. An ad just blew your eardrums out. Sorry about that, AP. I mean, I presume that it's still got to be... It's got to be running somewhere because the damn chats are going through. So, okay. So more or less, there are actual rules in place that say that because they were able to reach a verdict on 1 and 3, that those should have been entered. So she has made what I would call a considerable error of law in that respect. So I'm not surprised that they pursued the motion to dismiss. And if it's denied, I would fully expect that there would be an appeal made. So, but anyway, let's have a quick look so that I can... Oh, hang on. Where's the fourth juror stuff? Fourth juror says, Karen Reid not guilty of murder in new defense filing. Another juror in the Karen Reid murder case has come forward to say the jury unanimously voted to acquit her of second-degree murder and another charge in the death of her boyfriend, John O'Keefe, before a mistrial was declared last week in the high-profile case. Judge Canoni declared the mistrial on July 1 after the jury of 6 women and 6 men informed her that they were hopelessly deadlocked. Jackson said a fourth deliberating juror, Juror D, has now confirmed that the jury reached not guilty verdicts on count 1 and 3 of second-degree murder and leaving the scene of an accident with injury/death. Jackson said that the juror contacted him because they were uncomfortable with how the trial ended. I did read it, I just can't find the damn affidavit now for some reason. There was a whirlwind, everything happened fast. They recounted that from their perspective that when the jury was brought into the courtroom, the note was read, the mistrial was declared, the jury was then rushed out of the courtroom. They described it as all very confusing. The jury believed that they were compelled to come to a resolution on all counts before they could or should report verdicts on any of the counts, Jackson wrote. Juror D reiterated that they believed that it would be unjust for Karen Reid to be retried on either count 1 or 3 because the jury had already unanimously found her not guilty of those charges. On Monday, the defense filed a motion to dismiss 2 of the charges, citing communication from the juror and 2 people familiar with other jurors on the jury, as they had agreed unanimously that Reid was not guilty of the 2 charges and a retrial on such counts would violate double jeopardy protections. It's whether or not double jeopardy attached because she didn't enter the damn documents. YouTube's doing it, TV ads are increasing the volume for 0 reason. Yeah, and they try and, oh god, there's a name for it, where they try and throw as much sound in as possible to keep you, like, focused on it as well, which is BS. You need a jury that isn't retarded or some Baldwin master bullshit lawyers to beat the system. Bev was never going to allow Karen to be acquitted. Only Bev can't have Lally not get a second chance at a conviction. If true, why didn't they fill out those forms? Probably because they didn't realize they were allowed to. Like, it sounds really stupid, but stupider things have happened. If they genuinely thought that they had to come to a decision on all 3 counts before filling out the verdict forms, I mean, if they had filled out the verdict forms, if those verdict forms exist, if they're signed somewhere or whatever else, that would be all the more reason as to why that the counts 1 and 3 should be dismissed. I dare say that that's not the case, because it would be much stronger of an argument to say that they were. The day after the mistrial was declared, the defense started receiving communications from one of the 12 jurors and 2 people familiar with 2 of the others, saying that the jury had a firm 12-0 agreement that she was not guilty of 2 of the 3 charges against her. As of Monday afternoon, prosecutors remained determined to retry the case. The Norfolk DA's office is examining the motion in anticipation of filing a response. We look forward to picking a new trial date on July 22. Reid supporters protested outside the district attorney's office on Wednesday afternoon, spurred by news of the 4th juror coming out. After hearing news of it today about a 4th juror, I truly believe the DA and Judge Canone need to take a look at what happened at the end of the trial and maybe recall the jurors back and do a little hearing, said Reid supporter Paul Cristoforo. Well, he knows he's effed if he retries it. I think he's backed into a corner, personally. I think he has to retry it. But that doesn't mean that it's you know... So the court went to clown world. Pretty much. I think the notes would have read more like, we can't reach a consensus on all verdicts, or maybe the foreperson was a dipshit hell-bent on guilt. The annoying thing is that the language used by the foreperson in the notes was very verbose, and I think that actually probably hurt Karen, frankly. Do you have the original motion to dismiss, or just the just missing the supplemental of the fourth juror. I'm just missing the affidavit from about the fourth juror. I've got the motion to dismiss and the state's response. So he's in a corner, but he knows it's not going to go any better if he does it again. No, I agree with you on that, particularly now with what's happened with Proctor, the other issues with the Alberts, and thanks, Burberries. And I think now with the interlocking between that, the Birchmore case, hopefully the Root case, if that winds up in the Supreme Court, because that filing will be coming up soon, hopefully. The more that this gets dug into by the feds, the worse it's going to be for Lally. Let's put it that way. Didn't go to bed until 1:30 this morning, got up at 6:30. Ouch! Well, if it makes you feel any better, I didn't go to bed until like 4 and got up at 7. with a 5-year-old bouncing up and down on me, asking me how to create a dragon in Minecraft. Jackson said the juror was seeing inaccurate reports about the split amongst the jurors related to the mistrial. Juror A was emphatic that count 1, secondary murder, was off the table and that all 12 jurors were in agreement that she was not guilty of such a crime. Jury also unanimously agreed that Reed was not guilty of count 3, leaving the scene with injury/death. Is jury pools tainted at this stage? Yes, it very much is. And at this point, I think the argument to say that double jeopardy had attached is legitimate. And I think, personally, that by Bev screwing up and not... because she read that note and immediately jumped to going to a mistrial, because you know how... Well, we saw it in the Baldwin case. Did you notice how the judge there went through all of the elements of the mistrial, all of the things that were required of her, made a very clear record, whereas Bev just went, well, here's the note. Your jury service has concluded. I'm declaring a mistrial. You see the difference there? I personally feel like it's a very appealable issue. How do you make a dragon in Minecraft? You use a mod on the realms called Dragonfire. Well, it's a special world where you go around like summoning dragons and dinosaurs and all that sort of stuff. Bev can't let Karen get away. She's part of the fix. You're agreeing the notes read like a lawyer or an English major wrote them. Basically, we can't agree on anything. I was hypothesizing why. No, fair enough. So, all right, let's have a look at the motion, and then... Oh, hang on. Actually, I'll check whether or not that thing's come through from Breweries first. Because that was the one affidavit I haven't actually read personally. Didn't mean to send it 3 times. All good. Alright, so this is the one... Karen Reed's supplemental memorandum in support of motion to dismiss. As reflected in the attached affidavit of Alan Jackson, a 4th deliberating juror, D, has confirmed that the jury reached not guilty on counts 1 and 3. Alan Jackson's affidavit. Once they were dismissed, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on count 1 and 3? No one ever asked about those counts, which she very much should have. We need Baldwin Drudge to preside over the Karen Reed trial. She wouldn't take Lally or the McElwood shit. Nope. I agree with you on that. Juror D told counsel part of their discomfort was that they knew the jury had reached verdicts on 2 counts, and Karen Reed might be retried on those 2 counts, and that's just not right. Every one of us will agree and acknowledge that we found Karen Reed not guilty on counts 1 and 3, because that's what happened. And you know what the funny thing is? Very simple way for this to be fixed, and I can't see Bev doing it. Call the jurors back, poll them. Easiest way to settle it. If they say yes, she has to grant the motion to dismiss charges 1 and 3. If there's anyone that says no, well, then the mistrial stands, but I highly doubt it. Should have yelled out in court she was not guilty on 1 and 3, then jurors. Bev ain't going to do that. No, I don't. Look, if she doesn't, I genuinely feel like there may be cause for a application for judicial misconduct. If it was Trump, they would do everything they could do to find the man guilty. Well, based on the attached affidavit and all the reasons set forth in the opening motion, the fact that Juror D completely confirmed the veracity of the previously filed affidavits regarding jurors A, B, and C. The defense respectfully renews its contention that the jury acquitted Miss Reed on counts 1 and 3, or alternatively, there was no manifest necessity for a mistrial on those counts. Nice wording. And therefore, double jeopardy protections of the federal and state constitutions require those to be retried. Okay, so that's the covering motion. Do we have the affidavit itself? That's right. I don't think it matters. All good. I think someone in the state said they didn't poll juries. You still can. There's a civil case right off the bat. Would be my contention. The trouble is that the problem is that the error was on Bev's behalf, and she's got judicial immunity. So it's literally a case of you'd have to apply to probably the Massachusetts State Court. I don't know what the procedure is there, but I would sure as shit be filing an appeal on the basis of it, and I don't think they can really stand to not. So, because I mean, having that one go higher and having charges 1 and 3 knocked out entirely with double jeopardy applicable is a lot better than her potentially facing those charges again on a retrial. All right. That's all right. While we wait on that, I'll move to the motion. Because we got... This is the copy that was copied from the court, and it's actually less clear than the copy that I found for Jeff. How do they appeal a non-verdict? They're not appealing the non-verdict. They're appealing the judicial misconduct and saying that it was an error of a law that the judge engaged in by the way that she acted. So they're not actually appealing against the non-verdict, they're appealing against the actions of the judge in declaring the mistrial. Okay, where are we? I don't know that I need to read through the entire thing. Oh, what the hell? I love the language. The ancient right to a jury trial is no mere procedural formality, but rather a fundamental reservation of a power to the American people, Erlanger v. the United States. Don't you just love that? By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offences or arbitrary convictions. Prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact that Parliament and the Crown had deprived them in many cases of the benefits of a trial by jury. Star Chamber? Anyone? Oh, thank you very much, Burberries. Appreciate it. I'll come back to that in a minute. After securing their independence, the founding generation sought to ensure what happened before would never happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. The double jeopardy clause provides no person shall be subject to the same offence to be twice put in jeopardy of life or limb. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting them to embarrassment, expense, ordeal, and compelling them to live with a continuing state of anxiety and insecurity, as well as enhancing the possibility that, even though innocent, they may be found guilty. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that of the verdict of acquittal, that the verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. Can you explain double jeopardy? I know that there's a movie of the same name. Okay, so simply put, double jeopardy is a legal concept that applies in a criminal trial. If a jury is seated, if a trial proceeds to a certain point, and you're either acquitted by the jury, or, for example, you get a mistrial, if there's a good reason for it, the judge dismisses it with prejudice, the trial cannot be brought again. Double jeopardy is the rule that says that even if you are acquitted, the state, the police, cannot arrest you and try you and charge you for the exact same offense and have you go to trial again. Double jeopardy is when the questions are worth double. You know what? I can probably put that in slightly better terms. Give me 1 second. Oh, come on. The buttons aren't even working? Are you serious right now? Oh, man. That means I don't have any of my buttons. Hang on. Nope, that's road main. Main camera is off. There we go. 2 seconds. Where are we? Book, 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 book. Just want to make sure I get the right book. Doctrine of precedent. No, that's not what I want. Oh, to be in criminal procedure. What am I thinking here? Evaluating the law. Courts as lawmakers. Criminal procedure. Page 116. Make sure I get this right. Last thing I want is to get this wrong. Demand, burden of proof, sanctions, sentencing guidelines. You don't know? Ah, here we are. And I believe it's in the Constitution as well. Let's double check. Separation of powers. Da da da. The Senate, no. Proceeding there. Trial by jury, 80. Huh? Maybe it's not in the. Maybe it's not in the Constitution. It's been a while since I've actually read the Australian Constitution. But what I will grab is, while I'm here, is my legal dictionary, which is right there. Okay. Sorry to keep you waiting. I just don't like showing my fat ass on screen, so it's better if I just turn the camera off when I pick myself up. How would they retry her again then? Well, in this instance, because there was a mistrial declared, but it was not declared with prejudice, they'll be able to retry her, basically, and start all over again. Double jeopardy. The common law principle states that a person cannot be tried again for a crime which they have already been acquitted. However, advances in DNA technology have resulted in old cases being reopened and solved, or new evidence found, but the offenders are protected by double jeopardy. And where was it established? Defamation, no. Demerit points, no. Discretion, no. Exculpatory evidence, equity. Double jeopardy, the principle of criminal law that a person cannot be tried for a crime for which he or she has already been acquitted or convicted. Colin flipped out when John came to the house because of a formal complaint that he filed about to uncover a pizza ring. Oh, no shit. I think I said the premise of the movie Double Jeopardy is flawed because it's not the same case. Movie's okay, but it gets Double Jeopardy wrong. That doesn't shock me. Oh, we have a membership chat from Let's Go Brandon. I am, however, missing my damn social stream doc. So, hang on, what's it say? I feel like trial by ambush goes out the window when you drop 50 pages of instructions on juries. They need to rewrite the instructions. Well, I mean, look, the jury instructions are only one trial per crime, but no verdict. Trial never happened. Yeah, it's basically what's called. So a mistrial without prejudice is treated as if it is defunct ab initio from the beginning. They can literally go right back to the start and go all again. Hats off to all you lawyers. Too many words for me. Where are we? Clause guarantees that states shall not be permitted to make repeated attempts to convict the accused subject to their embarrassment. Oh, I already got that. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence is that a verdict of acquittal cannot be reviewed or on error or otherwise without putting a defendant twice in jeopardy, and thereby violates the Constitution. So basically, even if someone, for example, gets acquitted on a lack of evidence because someone misremembered, because some information was withheld or whatever else. I mean, if the defense in the Baldwin case had never known about those bullets, the trial would still be ongoing right now. But basically, because if someone is acquitted or convicted, then obviously you can't get So the point is that you can be acquitted, you can walk away scot-free and not be chased down for the same crime. If you are convicted, double jeopardy still applies because you cannot then be retried for the same crime and receive a higher sentence. If, for example, the legislation is changed or some alterations made retroactively, things like that. The pain, if you know, you know. Where are we? Here, the very day after a mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors, indicating in no uncertain terms that the jury had that firm 12-0 agreement that Miss Reed was not guilty on 2 of the 3 charges against her, including the charge of murder in the 2nd degree. Given the central importance to the acquittals that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Miss Reed on counts 1 and 3 and mandates dismissal of those charges. Alternatively, to the extent the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue and that the court authorize defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant on 2 of the 3 charges against her prior to indicating that to the court that they could not reach a verdict on the 3rd charge alone. Could easily become a mistrial. Your lying eyes deceive you. That trial never happened. This is not the trial you're looking for. What was the charge that were locked on? That was charge 2, which is this one. Manslaughter while operating a motor vehicle while under the influence. So they couldn't decide whether or not she was guilty of manslaughter while operating under the influence, whether or not she was guilty of involuntary manslaughter, or she was guilty of motor vehicle homicide. And whether or not they had aggravating factors in it as well. Didn't she pay for her lawyers, so she has to pay them again? If this goes to a retrial, yes. So that could easily be a daunting prospect for her. Shit, where'd the motion go? On 9 June 22, she was charged via 3 separate indictments with the murder in violation of Chapter 265, Section 1, vehicular manslaughter in violation of and leaving the scene of a personal injury or death in violation of the law. Jury trial began on April 16, 2024. On June 25, 2024, the jury began deliberations. On July 1, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review, which could be problematic for her as well, given that she immediately jumped to a mistrial. Rather, the court indicated that the jury was at an impasse. While the juror's note was read by the Honourable Court indicate the impasse was on charges, it did not say whether the charges were those within count 2, i.e. multiple ways to find guilt on count 2 or extended to other counts. The affidavits attached herein indicate it was the former, not the latter. Oh, no shit.
Sco, Brandon has donated $link and says also, Jackson's closing was slow in French, junk some of the conspiracy stuff and focus on he wasn't hit by a car, then go through the instructions and verdict form that requires him to be hit by car.
Yeah, and look, there were different bits and pieces of the closing statements that I didn't particularly enjoy. But at the same time, I mean, Jackson had to work with what he had. Like, I can be critical of the man all I want, but given that there are other cases now where I'm looking into it, and these people are, that was your worry about his closing too? Okay. I'm starting to believe, if I'm perfectly honest. Once the jury was seated, the court then read the jury note verbatim in open court and without providing any opportunity for defense counsel to be heard. So you could make an argument that... can you make an argument on due process there? The court declared a mistrial and excused the jury. In short, neither defense counsel nor the defendant consented to the mistrial, and the court never ascertained from the jury whether its deadlock was in relation to 1, 2, or all charges on the indictment in violation of that particular rule. On the following day, on July 2, 2024, Attorney Jackson was contacted by a jury in this matter, Juror A, who stated that they wished to inform him of the true results of the jury deliberations. According to Juror A, the jury unanimously agreed that Karen was not guilty of count 1, emphatic that count 1 was off the table, and that all 12 jurors were in agreement that this was not guilty of such crime. They also unanimously agreed that Karen Reed was not guilty of count 3. Another day later, on July 3, Attorney Yannetti was contacted by two different individuals, hereinafter referred to as Informant B and C. And I'll be perfectly honest, having read through Yannetti's affidavit, I cared less about them being contacted by intermediaries, okay? But now you've got two direct jurors and two intermediaries all saying the same thing. Received information from two distinct jurors, Juror B and C, both of whom were part of the deliberating jury in the case. Informant B sent Attorney Yannetti a screenshot that they had received from someone hereinafter referred to as Intermediary B of text messages that they received from Juror B. In that screenshot, Juror B texted the following: "It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit... What? No one thought she hit him on purpose or even thought that she hit him on purpose." Isn't it a lawyer's job to focus on not guilty instead of innocent? Yeah. To be fair, slow in French sounds... Love to see Jackson as a prosecutor. Hope I have the right thing. See him on the other side. That could be interesting. English is hard at times, yeah. Informant C had been in contact with another individual who was a co-worker in front of Juror C and joined a Zoom meeting during which Juror C discussed the trial. They sent Attorney Yannetti the below screenshots. No consideration for murder 2. Manslaughter started polling at 6-6, then deadlocked at 4 no, 8 yes. Okay, so there's a good chance that, okay. There's a time and place for the innocent argument, I'd say. Yeah. Interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip that was all confusing. She should have been acquitted, I agree. Yes, the remaining charges were what they were hung on, and the instruction paper was very confusing. What constitutes an acquittal is not controlled by the form of the action in question, according to Taylor. Rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all of the factual elements of the offence charged under Commonwealth v. Babb. The mere presence or absence of check marks on a form is not dispositive. Yeah, okay, so they're saying that just because they filled out the forms, just because they failed to fill out the form is irrelevant because the court itself failed to inquire as to whether or not they'd actually reached a verdict on any of the other two charges. Like, just love you commentating, Miss Oz, so much. Oh, no worries, Leslie. What's the temperature in Australia right now? Well, I mean, in the house it's quite balmy because I pay a rather exorbitant gas bill, but at the moment outside it is currently 50 Fahrenheit. The Zoom meeting negates your plea for remaining anonymous. I don't actually believe any of the jurors decided that they wanted to remain anonymous. It was once the defense filed this motion that Bev just turned around and said, yeah, you know what, we're locking down the identities for a good 10 days. So, Brisbane's about 18 degrees. I'm on the outskirts of Melbourne. Not by choice. I'd much rather be up in Darwin, if I'm honest. Thought it was weird Bev didn't bring them in to dismiss the jurors. Yeah. Jealous you're in fall already. Want to be in fall? Oh, it's not in fall. We're full-blown in winter at this point. We're shivering through it. 9.9 degrees in West Australia. Oh, that sucks. Okay, so there's case law saying that the forms themselves were not the definitive responsibility, and therefore that gives credence to the fact that Bev should have asked them. Because it would have taken all of 2 seconds. Did you form an opinion on any of the charges? Yes or no? Yes. Okay, which ones are they? Okay, can you go and fill out a jury form for those? Really freaking easy. And as far as I'm concerned, negligent on her part. Here are the attached affidavits by Jackson and Yannetti reflect statements by 3 deliberating jurors that the jury had reached final unanimous conclusions that Miss Reed was not guilty on counts 1 and 3. There was nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jurors' deliberations. Not going to bother going through all that. Okay, the Supreme Court's decision in Bluford is not to the contrary. There, a juror had reported during deliberations that the jury was unanimous against the charges of capital murder and first-degree murder, but split on manslaughter. The court sent the jury back to continue deliberations, and when the jury remained unable to reach a verdict, declared a mistrial. The Supreme Court rejected the defendant's argument that double jeopardy clause prohibited re-prosecution for capital and first-degree murder. In doing so, the court relied heavily on the lack of finality of the juror's report. The juror's deliberations had not yet concluded, and it went back to the jury room further to deliberate. Well, that wasn't the case. In this instance, it was at the point where they'd already deliberated for a significant period of time, and if it was at the point after the TUI instructions and Bev going, yeah, okay, we're at the point where I'm going to argue a mistrial. Sorry, I'm going to declare a mistrial. Then it's all like the deliberations had concluded at that stage. The instant she formed the opinion that it was time to declare a mistrial, deliberations had concluded, and it was appropriate for her to ask them. Here, by contrast, the juror's statements reflect a final determination that persisted through the end of deliberations. Even assuming arguendo and contrary to the foregoing, this court finds that retrial would not be prohibited under Bluford. This court can and should afford broader protection under Massachusetts state law. Unlike the United States Constitution, the Massachusetts Declaration of Rights does not include a double jeopardy clause, but our statutory and common law have long embraced the same principle and protections. You're saying that is normally how it's done for the judge to ask counsel. Generally, you're not just going to have a judge go, like, you're not going to... The judge isn't just going to offhand go, yeah, I'm declaring a mistrial. At the very least, they're going to ask the opinion of counsel. Or if they have any comment. She just steamrolled over the top of them. Cloudy in 77 in Malden, Massachusetts. Kind of presumptuous that she assumed it was hung on all charges. I'm not even thinking that it was presumptuous. I think it's true. I think she just did it deliberately. Okay, re-prosecution is independently barred because there was no manifest necessity to declare a mistrial on the counts for which the jury was unanimously agreed. I like this argument. Clarence Thomas is the only judge we need. We can get rid of the rest. Double jeopardy clause affords a criminal defendant a valued right to have their trial completed by a particular tribunal. Thus, where the mistrial is entered without the defendant's request or consent, retrial is impermissible unless there is a manifest necessity for the mistrial. That's a strong argument. They were not consulted. She immediately declared it without discussing it with counsel. Here, Ms. Reed did not consent to the declaration of the mistrial. Absent the defendant's consent, the state and federal double jeopardy protections bar as a general rule retrial a defendant whose initial trial ends without a conviction. The rule is rooted in the importance of the defendant being able, once and for all, to conclude their confrontation with society through the verdict of a tribunal that they believe to be favorably disposed of their fate. Accordingly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. There were no arguments as to whether or not it was appropriate. As I said, she didn't go through the elements of what a mistrial is, why it was necessary, why it was an issue. If Baldwin can be dismissed with prejudice, so can Karen. Absolutely. And there was probably more reason for Karen too. I wonder what other cases she's presided over. I've been meaning to do I've been meaning to look at that, actually. Because you can look that up. Alright. Before a court declares a mistrial for manifest necessity, counsel must have been given full opportunity to be heard, and the trial judge must have given careful consideration to alternatives at mistrial, per Ray, Massachusetts 463 at 4. Don't know about you. Oh, was that a ding? Oh, I forgot. Apparently, Bev has a high overturn rate. Which is ironic, because isn't she like the chief of the ethics committee or something like that? Which is a terrifying thought. Here, the defense respectfully submits that the lack of opportunity to be heard is alone dispositive. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel, which is a big no-no. She has to have detailed report as to why she ruled like that. The action was sudden, brief, and unexpected, neither preceded by nor accompanied by discussion with counsel, per Commonwealth and Horrigan. The record is independently lacking on the second prong as it reflects no careful consideration of alternative to a mistrial. Here there was one obvious alternative, simply to ask the jury to specify the charges on which they were deadlocked. Had the court done so and the jury articulated its verdict consistent with the statements of jurors A, B, and C, the double jeopardy implications would have been clear and decisive. Indeed, with being virtually unanimous, the cases have applied collateral estoppel to bar the government, so basically you can't make a claim, from relitigating a question of fact that was determined in the defendant's favour by a partial verdict. And there's already case law on this. When the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury has reached an agreement. The Supreme Judicial Court's holding in Commonwealth v. Roth, the courts should not request partial verdicts on lesser included charges in a single count does not pertain here, because it's literally... So if it was that they were having issues between whether or not it was part of charge 2, whether or not it was the main charge, whether or not it was a lesser included, the court can't enter a partial verdict on like one of the three. So, for example, if they were answering this form here, the court cannot go to them and say, well, hang on, do you find them guilty of any one of these but not the others? Because if there's a possibility of deliberation or there's a split on say 2, 3, or 4 on this form, that's a no-go for a partial verdict. I think the last case was another hung jury case that was retried and came back guilty the second trial. I'm not shocked. Does she have above to answer to? Only if they actually do something about it. That's going to be the problem. Split a case of wine with Bev, to be honest, just to see what goes on in her brain first thing in the morning. Oh, let's go. That's horrifying. Oh, no, wrong button. Judicial courts holding in Roth, blah, blah, blah. As the Roth court acknowledged, inquiry concerning partial verdicts on lesser included offences that have not been separately charged carries significant potential for coercion. Such inquiry, in effect, implies that the jury should consider conviction on the lesser count. No similar danger is present here, as here the jury was asked to return 3 separate verdicts on 3 separate counts. In the circumstance where the juror reports a deadlock without specifying on the counts on which they have reached an impasse, it is straightforward, and the defence contends constitutionally required to follow up to ask whether the deadlock relates to some as opposed to all counts. Indeed, the Supreme Judicial Court has explicitly stated, where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts despite deadlock on the other counts. Alternatively, the defence is at least entitled to conduct post-verdict inquiry. Unassigned counsel did not initiate communication with jurors A, B, and C, and now D, which resulted in the disclosure of information that is memorialised in the counsel's affidavits that are appended to the motion. Should this court find that further factual development is required, the defence respectfully requests that the court conduct a voir dire, Jeff, voir dire, of the jury and or an evidentiary hearing to substantiate the existence of an acquittal. Should the court seek the affidavit of each juror, such as A, B, and C, and now D, the defence asks for the court to authorise underside counsel to initiate contact for the sole purpose of asking each juror whether the jury had unanimously agreed that the defendant was not guilty on counts 1 and 3. The Supreme Judicial Court has held that because of the importance of the issue, juror bias is a legitimate subject for post-verdict inquiry. It is similarly a fundamental tenet of our system of justice that a defendant may not be retried for a crime for which they've previously been acquitted by a jury, and the defence submits that post-verdict inquiry is equally warranted in the present context. I would agree. It just started raining. That sucks. Just as the court in McCallum approved questions as to the existence of racial bias, questions about the matter more attenuated to the content of deliberations, whether the jury had unanimously concluded that Miss Reid was not guilty on counts 1 and 3, do not invade the heartland of jury deliberations, but preserve the defendant's precious rights to the favourable outcome of a jury trial and to the protection of the double jeopardy clause and its related state judicial protections. This is the biggest problem. No, you can't interrogate the jurors post-verdict. I would disagree. The funniest part of this is that they only came forward because of that dipshit on Twitter spreading the misinformation about the 10-2 guilty. Yeah, that is true too. God, that was... For the foregoing reasons, Mr. Reed respectfully requests that the Honourable Court issue an order dismissing counts 1 and 3. It's an extreme measure. Yes, but in this case, I believe that there's been extreme malfeasance by the judge. I would consider that it is a necessity at this point. I mean, if nothing else, if this were to wind up on appeal, well, not even that. If they were to make a complaint out of it, I should say, against Bev's conduct, they can't really even order anything on it, which is really freaking frustrating. I think it's a Massachusetts thing, which is why they're having to ask the judge to inquire. Okay, so that was that. And Brewer sent through the 4th affidavit, which I'm very thankful for. I'll just pull this up and make sure I'm not showing any of my messages or anything like I usually boom on my way through. No, it looks good. That's fine. And then open image in new tab. All right, so I've got that there. All right, so this is the plaintiff. This is the supplemental affidavit in relation to Juror D. Monday, 8 July 2024, I was contacted by Juror D. Based on my conversation, I've identified them, blah, blah, blah. Juror D told me that they decided to reach out because they had been uncomfortable with how the trial ended. They said that the last day of the trial was a whirlwind and everything happened fast. They recounted that the perspective was the jury was brought into the courtroom, the note was read, and the mistrial declared. The jury was then rushed out of the courtroom. Following a brief meeting with the judge, the next thing they knew, they were all on a bus. They described the end of the trial as very confusing. Well, I think there's a few people that found it confusing. Juror D said that it was very troubling that the entire case ended without the jury being asked about each count, especially counts 1 and 3. They explained the jury had reached not guilty verdicts on counts 1 and 3, and that the disagreement was solely on count 2 and its lesser offences. Juror D said that the jury actually discussed telling the judge that they had agreed unanimously on not guilty, but that they were not sure if they were allowed to say so. And that, I think, is an issue. Who's going to order the jurors in? I would say that Bev requesting their presence, whether it's voluntary or whether or not they issue a... I don't want to say subpoena because I know that's not the correct thing. It's going to be better if they're in Bev's court than they are in the Supreme Court. Let's put it that way. In Massachusetts, they aren't allowed to reach out to the jurors without judge's permission. Which is why they reiterate that it was unsolicited contact by the jurors to them. Yep. Juror D said that the jury actually discussed telling the judge. Jury believed that they were compelled to come to a resolution on all counts before they could or should report verdicts on any of the counts. After discussion, the jury decided to inform the court that they were deadlocked and that they expected that they would get further instruction about the remaining decided counts thereafter. Juror D explained that he or she was confused and upset that further instruction never came. So because Bev made a fuck up, the jury were, at least 4 of the jurors out of 12 are upset, which I think is entirely correct. She does seem bipolar. Might be over, but they did come to a verdict, it seems. Yeah, and that's really the issue here, because there is case law and there are court rules that basically say that Bev done fucked up. And that she should have asked the jurors. They explained that after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended and were wondering is anyone going to know we acquitted Karen Reed on counts 1 and 3? No one ever asked about those counts. Juror D stated that once the case was over, they remained very uncomfortable with the result, that it did not feel right. He knew that the jury had reached the verdicts on 2 counts and Karen Reed might be retried on those 2 counts, and that's just not right. Well, no, it's not. I inquired whether, in their opinion, other jurors would agree and acknowledge the not guilty verdicts that were reached on counts 1 and 3. They said without hesitation and in substance, every one of us will agree and acknowledge we found Karen Reed not guilty on counts 1 and 3 because that's what happened. Juror D reiterated that they believe that it would be unjust for Karen Reed to be retried on either count 1 or 3 because the jury's already unanimously found her not guilty of those charges. Juror D further stated that if necessary, they would agree to testify in order to explain to the court that the jury unanimously reached not guilty verdicts on count 1 and 3 as long as their identity remained protected. Hey, Jude. Just file the same motion every day to make sure you get her in a good mood. When Jackson brought the motion about the verdict forms, Bev knew she messed up and created an appellate issue. Yeah. And I'm not going to lie. She honestly thought, in my humble opinion, I honestly believe she saw declaring a mistrial as a way out of that being an appellate issue. I really do. I think she saw that as a way to rip the Band-Aid off and make sure that that was not something that wound up in front of a higher judge. Yannetti should begin with John O'Keefe was not hit by a car instead of Karen Reed was framed. Alright, so, what's happened since then? Well, we've had the Commonwealth's response. I haven't read it, I haven't seen it, I don't know any of the details or any of the content. We're going to go through it. It's like 19 pages, but after that, we'll try and do some funny stuff. We'll try and, like, make it a little bit more lighthearted and whatever else, okay? Because this is, I'm not going to lie, going to be a slog. Probably didn't help that she actually said it was late and she was tired and was looking, when she was looking over the forms. Nope, I agree with that. But it wasn't a mistrial, it was a trial with jeopardy. I agree with you, Benjamin. That's why I'm saying she should not have declared a mistrial. She done fucked up. Alright. Should be this one. Nope, that's the motions. That one. Okay. Now, apologies, because I did pull this off of Reddit, so it's a little bit fuzzy. Commonwealth's opposition to defendant's post-trial motion to dismiss. Now comes the Commonwealth in opposition to the defendant's post-trial motion to dismiss her indictments of second-degree murder and leaving the scene causing death, as the defendant's motion is premised upon hearsay, conjecture, and legally inappropriate reliance on the substance of jury deliberations. I'll get nicked. The lawyers want a mistrial, which is good, but for that bill, they shouldn't have stuffed up the strategy so much. It's all good, Lil Pill. Don't stress. Only an hour late. Further and contrary to the defendant's claims throughout jury deliberation, the defendant was given full opportunity to be heard. Wait, what? It specifically says whether or not someone should be heard in relation to the mistrial. This is obfuscation on a grand scale, in my opinion. Oh, yes, because they were in deliberations, and they were supposed to stick their hand up and say, yeah, Your Honor, we're not happy with the thoughts of declaring a mistrial, because we're expecting it to come back with a not guilty verdict if we're lucky. Judge declared a mistrial because she wanted to go home early and eat a tub of ice cream. What a joke. The jury's communications to the court explicitly indicated an impasse on all charges, and the court carefully considered alternatives before declaring a mistrial. How do you know? How do you know that the court carefully considered it when the court provided no reasoning as to any consideration, no reasoning as to what the requirements were, and no reasoning as to, oh, I don't know, any alternatives? This is just lip service. Lally is kissing Bev's ass so hard here that it's not funny. The defendant's unsubstantiated but sensational post-trial claim that the jury reached a unanimous decision to acquit lacks any merit or legal foundation. What? At this point, you have two actual serving jurors saying that they reached a verdict, and one of them is an actual juror saying, hey, we didn't think we were supposed to say anything because we didn't think we were allowed to. I'm sorry, that's a fuck-up of court procedure. That's nothing else. On June 9, 2022, the defendant was indicted by Norfolk Grand Jury for second-degree murder, manslaughter while operating under the influence, and leaving the scene of a personal injury or death. On April 16, 2024, a 10-week jury trial commenced. The jury began the deliberations on June 25, 2024. In addition to the 3 indictments, the jury were instructed to consider 2 included lesser charges to manslaughter while operating under the influence, involuntary manslaughter in violation of Chapter 265, Section 13, and motor vehicle homicide operating under the influence of liquor and negligence. The defendant's motion states the court's decision to declare a mistrial was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. It wasn't. It's on camera. Why didn't Bev put the not guilty box incompetent or scandalous? We got 1/3 of the foundation, let him lay the rest unbiased prosecutor. I would argue that saying that it's unfounded and scandalous is ridiculous, because if even one juror comes out saying that and it can be verified that it's true, oh, that's okay, Jedi Jess, I appreciate it, but I can read this, that's fine. Although, actually, can I? Oh yeah, that works. The defendant's motion states the court's decision to declare a mistrial was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. They had every opportunity. Bad wording. Bad, Hayden. Bad. They should have had every opportunity to make comment after she read the note out. It doesn't matter what opportunity they had to comment on anything prior to that note, because that note coming back from the jury that she read verbatim said that they were deadlocked on various issues. It is at that point, and only after that point, that counsel have the opportunity to discuss whether or not they agree and consent to a mistrial. Because it is only at that point that Judge Bev had come to the conclusion that she was deciding that she was It was only at that point she'd come to the conclusion that she was intending to grant a mistrial. That is when the appropriate time is. The money spent on the trial was not small either. Nope. Paperwork for the boxes to tick them 1 guilty, 2 not guilty, 3 other. They lost on drawing alternates too. She let them have arguments with every other note but that one. Yep, because she was expecting for Lally to be able to make arguments that she could rule on, basically. Beginning on Friday, June 28, 2024, at approximately 12:15 p.m., the jury sent a note stating, writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. Notice how that makes the language that he used on the first page disingenuous as well? Writing to inform you on behalf of the jury that despite our exhaustive review of the evidence, our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. Okay. A unanimous verdict. You were supposed to return 3 unanimous verdicts. Which unanimous verdict are you unable to reach? That of itself should have triggered them to go, hey, which ones? It's all in the wording. And then for Lally to go in and say, oh, the note explicitly referred to all charges. No, it didn't. It says, we have been unable to reach a unanimous verdict. Here's an example. They got the patient at the hospital, but they didn't tell the hospital, so he died. Okay. It's also on our lawyers, though, if we're being fair, speak the fuck up. I think they knew there were some guilty votes in there and wanted out. Well, again, Brandon, I would have to disagree with you because with how quickly it happened, they didn't have the opportunity to. As soon as she read that note, she went, in the next breath, she went to, I'm declaring a mistrial. They lost the opportunity to object at that stage because she'd entered an official court ruling. She can't just go back on that. She made the pink one and only answer. Only one answer. Just did a couple of dishes at your sink. Oh, good. At that time, the court requested an argument from the Commonwealth and defendant as to whether or not the jury had engaged in due and thorough deliberations. Oh, hang on, that's the previous... No, wait, that's the previous note, isn't it? Yeah, because then they went on to the 2 in... My bad. Court responded to the jury had not had sufficient time to deliberate and requested the jury be instructed to continue the deliberations. On the contrary, Yannetti argued that we believe there's been sufficient time and advocated for the jury to be declared deadlocked and provided Tui Rodriguez instruction. Yeah, moving towards a mistrial. That doesn't mean that you... Oh my god. Attorney Yannetti stated the word exhaustive is the word I think it is... operative here. They're communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and that they're at an impasse. You know, this is a case where the jury has the legal instructions. They've only really asked one question, which was to try and get a report that they were not allowed to get, and I think the message has been received that the evidence is closed and they won't be getting anything more. They've been working essentially non-stop for the last 3-4 days. We're approaching the weekend. They didn't come back with this at 3 or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is that the jury should be read the Tui Rodriguez model instruction and go from there. All these filings are disingenuous. I'm not going to lie. That's what you expect it from the defense, though. The prosecution is just literally 2 minutes and 16 from calling in the attorneys saying we have a note, jury called in, note read, her declaring mistrial and dismissing the jury. The argument that Yannetti was pushing for the Tui Rodriguez instructions does not apply to whether or not there was been genuine considerations to whether or not there are alternatives to a mistrial being declared. Again, this is Lally being incredibly disingenuous. Where are we? The court ruled that given the length of the trial, number of exhibits and complex issues in the case, that there had not been due and thorough deliberations and instructed the jury to continue deliberating. On Monday, July 1, 2024, at approximately 10:45 a.m., the jury sent another note stating, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinion and state of mind. The divergence in our views are not rooted in lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implication that it holds. Following receipt of that note, the court again inquired of the Commonwealth and defendant as to whether or not there had been due and thorough deliberations. The Commonwealth argued that although the jury had been deliberating for approximately 22 hours, given the length of the trial and number of the witnesses, the jury had yet to engage in thorough deliberations. Attorney Yannetti again sought Tui Rodriguez instructions, stated that the jury has come back twice, indicating essentially that they're hopelessly deadlocked. They said that they've been over all the evidence, and at this time they say there have been fundamental disagreements about what the evidence means. It's a matter of opinion, it's not a lack of understanding. Now, don't get me wrong. Do I think at any point they could have actually asked for it now? Yeah, they probably could have. They could have piped up and said, hey, can we ask them what they're deadlocked on? Absolutely, they could have. It doesn't change the fact that Bev fucked up. Lally's all the words that he doesn't even understand. I think they literally followed the line in the note where they said deliberating more would only force him to compromise their deeply held beliefs, and then she said, I'm not going to do that. Yeah. The court found that at this point the jury had engaged in due and thorough deliberations, noting that they had been an extraordinary jury. This has been an extraordinary jury. The court had indicated it had never seen a note like this reported to be in an impasse. At approximately 11 a.m. on July 1, 2024, the jury was advised of the full Tui Rodriguez instruction, including that it was the jury's duty to decide the case if you can do so conscientiously, and that there was no reason to believe another jury would be more competent to decide this case. On July 1, 2024, at approximately 2:30 p.m., the jury sent a final note. Okay. Now, I need to be very careful and I need to read exactly what was said here, because this is where it goes from, here's the note, to the mistrial. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof establishing the elements of charges beyond reasonable doubt. Conversely, others find the evidence fails to meet this... Oh crap, did I just change it? I think I just closed that by accident. Oops, hit the... There we go. You know, I'm just going to open all of these so that I can just go to them. Make it easier. 9, 10, 11, 12, 13. Oh, look, and 14, because I'm not going to bother opening 15. Okay. The standard, and does not sufficiently establish the necessary elements of the charges. The deep division is not due to lack of effort or diligence, but rather sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only force us to compromise our deeply held beliefs. Following receipt of the note, the court discharged the jury and declared a mistrial. Show me where in that wording In that paragraph, show me where it says that they are hopelessly deadlocked on all charges, which is part of the opening paragraph of this motion by Lally. That's why Coffender made her statement on Twitter about Tender 2. It's ridiculous. Yeah. Okay. The representations made in counsel's affidavit have no legal bearing on the mistrial, as the jury did not reach any verdicts, partial or otherwise. A juvenile v. the Commonwealth, verdicts must be reported in open court, which they would have been had she not engaged in misconduct, in my opinion. Did the foreman cut and paste from the instructions to write these notes? Plagiarism lawsuit incoming. I honestly don't know. I really just, like, whoever the pompous git was that was the... Well, actually, to be fair, we don't know that it was actually the foreman. It could have been someone very overbearing and saying, hey, I want this written out in this manner and I want this to say it exactly this way so that we look good in front of Judge Bev. The only verdict which can be received and regarded as a complete and valid verdict of the jury upon which a judgment can be rendered is an open and public verdict given in and assented to in open court as the unanimous act of the jury and affirmed and entered into the record in the presence of and under the sanction of the court. Which I agree with. What I disagree is where there is a circumstance where the court itself circumvents the ability for a verdict to be entered. Which is what she did. It is literally part of Massachusetts rules that she is supposed to say, well, hang on. Can we enter any of the verdicts on any of the counts? Can't wait till the entire investigation is complete and see the McAlbert's officers, DAs, and possibly Annie Bev in cuffs. We'll see. Don't think there's anything wrong with the jury note. Nope. Where are we? Verdict which determines the rights of the parties and is admitted to the record upon which judgment is rendered is the verdict received from the lips of the foreman in open court. It is not enough to... At no point were they asked whether or not they had a verdict. That's the problem that I have here. It's not enough to show that the jury may have agreed on some issues at some time. If that limited showing were to control uncertainties would be invited. No error in the judge's refusal to accept the not guilty verdict slips found in the jury deliberation room after the jury was discharged, where those slips were in contradiction to the jury's report to the judge. That's a separate matter. The hearsay comments and juror statements about what happened are legally irrelevant as the jury failed to reach any verdicts. In Blueford, the jury sent a note to the court indicating they were hopelessly deadlocked, and the court asked the foreperson to disclose the jury's votes on the 3 charges. Additionally, we could build a wall around Massachusetts until we figure out how to move the entire thing to the West Coast, and nobody would lose any sleep. First degree murder, manslaughter, and negligent homicide. The foreperson reported the jury unanimously agreed that the defendant was not guilty of murder, but were deadlocked on manslaughter and had not voted on negligent homicide, which is what should have happened. Hello, Jonathan Irwin. How are you doing? The foreperson reported the jury unanimously agreed. Oh, I got that. The court gave the jury an Allen instruction akin to a Tui Rodriguez instruction that emphasized the importance of reaching a verdict and instructed the jury to continue deliberations. After a half an hour, the jury reported that they had not reached a verdict and the mistrial was declared. The United States Supreme Court rebuffed the defendant's claim that the jury acquitted him of murder, as the foreperson's report was not a final verdict because the jury had continued to deliberate and, more importantly, gave no indication as to there was still being any that they were still unanimous on the murder charge. We're talking about when it's contemporaneous for the verdict to have been reached, though. That's the thing. Can't forget the foreperson was handpicked by Judge Bev. Oh, well, you know what? I did forget about that, but thank you. The United States Supreme Court emphasized that when jurors engage in discussions about the circumstances of the crime, it often causes one to rethink their stance on a greater offense and revisit a prior vote. The very objective of the juror system, after all, is to secure unanimity by comparison of views and by arguments amongst the juror themselves. A single juror's change of mind is all it takes to require the jury to reconsider a greater offense. Okay, that's fine. But if they don't actually ask whether or not anything's been reached, then that, in my opinion, is misconduct and it's inappropriate. What the hell is going on in chat? Okay, you know what? Fine. Doesn't matter. Okay, next page. It must be recognised that as a practical matter, that the jury votes on included offences may be a result of temporary compromise in an effort to reach unanimity. A jury should not be precluded from reconsidering a previous vote on any issue, and the weight of the final adjudication should not be given to any jury action that has not returned a final verdict. That's why the first slip was objected to. A jury should not be precluded from reconsidering a previous note on any issue, and the weight of final adjudication should not be given to any jury action that has not returned a final verdict. But they should still be given the opportunity to return a final verdict, not as a result of court misconduct. Jesus, Lally, come on. The jury's notes were unambiguous that the jurors were deeply divided by fundamental differences in our opinions and state of mind that resulted in a starkly divided jury as to the charges. It didn't say charges. It specifically... Okay, the only time I said charges is where it said that there was stuff that did not necessarily establish the elements of the charges. Like, oh my god. So that would lend credence to there being a not guilty verdict. Oy. Where are we? Jury consistently indicated that the impasse was not due to lack of understanding of the law or the charges, but a profound divergence in deeply held convictions, ultimately leading to a point where the consensus is unattainable. The jurors' notes did not indicate agreement or acquittal on any of the charges. Rather, it was evident the jury was unable to agree on any of the charges due to their sincere adherence to the individual principles of moral convictions. Bullshit. Contrary to representations made in the defendant's motion and supporting affidavits, the defendant advocated for and consented to a mistrial. I'm sorry, what now? As she had adequate opportunity to object and instead remained silent, which removes any double jeopardy bar to retrial. Hang on.
Kevin Conwell versus Karen Reed.
All right, the jury is at an impasse. So we'll bring them in. All right, Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt.
Oh, I stand corrected.
Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges.
Ooh, okay, rethinking about that may give some credence to one of Lally's arguments.
The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete.
Show me where the opportunity for an objection was. Literally, finished reading the note, went straight into your service is complete, I'm declaring a mistrial. Show me where the opportunity to object was. Or where the consideration and consultation with counsel was. Bloody hell. I have a feeling jury was going to say not guilty, but a few with higher education knew how to railroad to a mistrial and the judge did not fight what was going on. During her full opportunities to be heard on June 28, 2024 and July 1, 2024, at no time did any of the defendant's three counsels request inquiry as to what charge or charges the jury was deadlocked on. I will give him that. That is some bullshit. I do think they probably should have done that too. Rather, the defendant was quick to request a Tui Rodriguez instruction at the first opportunity, indicating a belief based on the clear and obvious language of the jury's notes that, as stated by Attorney Yannetti, the jury was hopelessly deadlocked and exhausted all manner of compromise, and was engaged in fundamental disagreements as to what the evidence means. It's a matter of opinion, not a matter of understanding. Furthermore, following the discharge of the jury, the court engaged the Commonwealth and the defendant in discussions about choosing a status date for the scheduling of a retrial. At no time during the hearing did the defendant object or indicate displeasure with the mistrial. In her original instructions, she clearly stated not to let anyone know about the current state of the votes or the split, so I feel the S was added to make it more obscure. Prosecution didn't even argue accidental. Counts 2 and 3 are examples of what I would consider reasonable doubt to what they actually argued. Mistrial was also supported by manifest necessity, jury deadlock. Frequent traditional example of manifest necessity to declare a mistrial is where the jury were discharged because they were unable to come to an agreement on a verdict v. Thames and the Commonwealth. Re Thames and the Commonwealth. Trial judge is best situated to determine whether the ends of substantial justice cannot be obtained without discontinuing the trial. In declaring a mistrial, premised upon the trial judge's belief that the jury is unable to reach a verdict, the decision is treated with great deference, because otherwise there would be a danger that the judge would employ coercive means to break an apparent deadlock. The court engaged in considerable efforts and sent the jury back to deliberate 2 times following notes that they were at an impasse, in addition to finding that the jury had engaged in due and thorough deliberations and providing the Tui Rodriguez instruction. At the request of the defendant and to her satisfaction during deliberations, the court amended the verdict slips to depict clearly the lesser included offences and provided the jury a supplemental instruction on how to consider the lesser included offences. The defendant's claim that the judge should have inquired of the jury holds no merit, as nothing in our case law or in Chapter 243, subsection 34, required the judge to make either inquiry, whether there was reasonable probability of unanimous verdicts or if the jury would consent to further deliberations as a matter of course, and the circumstances before the judge did not necessitate either inquiry. Well, that's bullshit. The defense didn't object because there was an assumption that there was a deadlock on all charges, not just some. Look, I'll be perfectly honest. I would say that they screwed the pooch on that. I still think that they should have asked irrespective. If she'd turned around and said no, then I think it would be a stronger case against it. But final note from the foreperson unequivocally stated that jurors were unable to come to a unanimous decision. In other words, the jury were deadlocked. The note did not suggest, for example, that the jury were merely having trouble making a decision or needed further instructions from the judge. Given the 4 days of deliberations, the jury's indication that they had carefully reviewed all the evidence and their divergent opinions were premised on a deeply held moral conviction, the court was left with no reasonable alternative other than to declare a mistrial. Bullshit. A reasonable alternative was to ask what they're deadlocked on. Really freaking straightforward. Scary is that the jurors said that they thought she hit him, not just intentionally. One of the affidavits said juror vote not guilty on deadlock, one because Cole killed him, not to hit. Further consultation with counsel would not have produced any fruitful alternatives, nor was there a reasonable probability that the jury would have consented to deliberate further, particularly when the jury wrote to continue to deliberate would be futile and only serve to force us to compromise our deeply held beliefs. If the jury is literally of the mistaken belief that they have to come to unanimous decisions on all counts, prior to providing the court with any information, then that is a fuck up on behalf of the court. It's plain and simple. When we lost in all this speculation, if Bev had only bothered to poll the jury, then we would know what their positions were. Yeah. Actually, where did that... The rule provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. See the ABA standards related to trial by jury, subsection 545. Rules of Criminal Procedure, Rule 541. So, Lally, do me a favor and just like, hang on, you know, I'm going to close some of these because clearly I'm getting a little ahead of myself. Show me exactly where there's nothing, there's no law, there's no rules, there's no whatever else that say that it's a requirement. I mean, clearly you can just try and cover over that, but moreover, where the counsel initiates contact with a discharged juror by first sending a notice to the opposing party with the substance of proposed communication, or if the juror initiates contact with counsel, as alleged by the defendant's motion, counsel may communicate with jurors only about permissible subjects. Are you seriously going to say that it's not okay for oh my god. He's actually going to try and make the argument that counsel wasn't allowed to talk to the jurors about the verdict. Permissible subjects include counsel's performance during the trial, extraneous influence on the jury's deliberation. Extraneous influence on the jury's deliberation. You know, like the judge giving an incorrect instruction or providing a faulty jury form. Also stated they felt uncomfortable that the Alberts were all there. Extraneous influence on the jury's deliberation. Or a juror's bias towards the defendant. Neither extraneous influence nor a claim of juror bias is alleged by the defendant to have been an issue. I would disagree with that. Rather, what the defendant's motion is entirely premised upon is that it is and what is expressly prohibited inquiry is that the jury's deliberative process and the substance of the jury's deliberations. It is improper for counsel to inquire with jurors or through intermediaries the individual or collective thought processes of the jury, the reasons for their decision, or the substance of their deliberations. Massachusetts continues to adhere to the common law principles barring inquiry into the contents of jury deliberations and any impeachment of jury verdicts based on information gained from such inappropriate inquiry. Similarly, it would be improper for the court to inquire, through affidavits or an evidentiary hearing, the substance of the jury's deliberations. If after communicating with a juror, an attorney wishes to secure an affidavit from the juror, any such affidavit must focus on extraneous influences and not the substance of the juror's deliberations or the individual or collective thought process of the juror or the juror as a whole. The trial judge acted within discretion to declare a mistrial where a proposed inquiry of deliberating juror could not be made without inquiring into the deliberating process of the jury. The Supreme Judicial Court has instructed that wherever a judge asks individual jurors about the possibility of extraneous influences on the jury deliberations, whether the jurors who are still sitting, such as jurors who have been discharged, the purpose of the individual voir dire is not to delve into the jury deliberations, there should not be an inquiry into a juror's individual or the jury's collective thought processes. I would argue that this is not about whether or not they're talking about the thought process or the deliberations. It was whether or not a verdict was reached. I would argue that that is extraneous to what is contemplated. If the form was off, that's on the lawyers for not getting ahead of it. To be fair, Bev was a bitch about it. Does anyone else think Lally doesn't own a TV or have internet access at home? He just stares at the wall all night? Possibly. He could well. We don't know. Likewise, polling the jury on the various possible verdicts during the deliberations or after the discharge will constitute an unwarranted and unwise intrusion into the province of the jury, and the Supreme Judicial Court has cautioned strongly against the risk of coercion inherent in questioning jurors, particularly in individual colloquies. Literally, was this... No, fuck that! Fuck that! It is literally a question that gets asked after the verdict is returned in court. Juror number 1, is this your verdict? Juror number 2, is this your verdict? Juror number 3, is this your verdict? Jurors, was a verdict reached on any of the charges prior to the mistrial being declared? Okay, what's it say? One cannot assume from the mere report of a deadlock that there is any final verdict lurking within the deadlock that may be extracted. In many instances, asking a deadlock jury about a partial verdict would constitute attempting to extract from the jury something that does not exist. Asking a jury to report where they stand on an offence as charged invites a report that may be based on only preliminary tentative deliberation. Okay. I can understand that you wouldn't want to do that during a trial. You don't want to influence the jury. But if a juror comes forward after the fact, and that the fact that certain verdicts were not reported as a report of the judge's malfeasance, then that has to be some sort of appealable error. This is driving me insane. This is going to drive me batshit crazy, honestly. Such inquiries, the jury may succeed in extracting a partial verdict, but would not have a confidence that the partial verdict was a product of a thoughtful and thorough deliberation process. Well, no, because they're talking about whether or not a verdict was reached at the time after the trial. This is literally saying, can you go back to where they say the judge has no duty to inquire? That should be on this page. Shit, where did it go? It is improper for counsel to inquire with jurors or through intermediaries, individual or collective thought processes. Similarly, it would be improper for the court to inquire through affidavits or an evidentiary hearing the substance of the jury's deliberations. We don't care about the substance of the jury's deliberations. We care about whether or not a verdict was rendered. Also, Jedi, thank you very much for the super chat. Very much appreciate that. That coupled with Brandon puts us $35 away from dog cam and puts me 600 and something away from a mystery item. This case law to me doesn't apply. This is not a partial verdict. This is 2 verdicts that were reached and one was deadlocked. So how does this even apply in this situation? Thank you! Someone gets it! Thank you! Proctor's already on the sidelines, probably going to be Brady listed. The case is drowning. Yep. What did I get to? Even if the deadlock does pertain to some distinction between the various levels of an offence, a judge has no way of knowing whether the jury in fact have fully considered the offence as charged. You're not talking about a verdict that's been reached after the fact. It's literally get the 12 of them in there and say, at any time prior to the judge declaring a mistrial, was a verdict reached on any of the charges? It's a simple yes and no. If the answer is yes, then you're not talking about the substance of the deliberations. You're asking about an overall verdict that should have been provided to the court. And frankly, it would be inappropriate to not get that on the record. Desire to extract information from a deadlocked jury does not solve the significant problems in attempting to do so. Court's inquiry into possible verdicts improperly intrudes on the jury's function, and the ostensible benefits to be gained by such procedure are outweighed by its risks. For the foregoing reasons, the defendant's motion should be denied, as there was no verdict that acquits the defendant, no grounds for the court or counsel to inquire as to the deliberative process of a discharged jury. The defendant consented to the mistrial bullshit and declared, oh, whoa, Jill.
Jill Ems has donated a dollar link and says, just want to thank you for answering all my questions, so I will pay it forward.
Not a problem. Happy to help and happy to pass what I can. Appreciate it. Also, sorry, Jedi, I'll read yours too.
Jedi Jessa has donated dollar link and says, can you go back to where they say the judges has no duty to inquire?
Yep, and I did. That's fantastic. There you go. So that's 25. So, oh yeah. So we're still 25 away from unlocking Doggo Cam. Or should I say, the Labracadabrador. This is a no-lose proposition. Prosecutor is corrupt. Okay. The court properly declared a mistrial due to a deadlocked jury, who was at an impasse due to their starkly divided perspectives on the evidence and their sincere adherence to individual principles and moral convictions. As such, retrial is not barred by double jeopardy or constitutional principles, and the Commonwealth may retry the defendant on the 3 indictments and any appropriate lesser included offences. I call bullshit. The DA's office is under investigation, so it's not too far of a stretch. This is true. Also, that reminds me, the Birchmore civil case had a hearing yesterday or the day before. It was done on Zoom. It's not on YouTube except for one guy that streamed it, and I don't really want to stream someone else's stream. If anyone knows of anyone that, like, covered that, or that didn't do it with, like, showing super chats and all that sort of stuff, please let me know. Because I can go back and sit and watch it, but I can't stream the guy's stream. That's just rude to me. My charger just came out of the plug, damn it. Oh, that sucks. So that's pretty much where we're sitting on the Karen Reid stuff. The odds, just call them in and ask them if they reached a verdict, like you said, and get the truth. Exactly. Because if a verdict was reached prior to her declaring a mistrial, it's a proper verdict. It just wasn't announced in open court because Judge Bev screwed the pooch. It's not asking if a partial verdict was reached. It's asking whether or not a full verdict was reached on any of the charges. If I ever get a channel, I have to come up with a name for the Jackawawa cam. I fully expect this to be denied. I fully expect Jackson's motion to be completely denied. The case they cite for the no inquiry says that they have no duty to inquire if they are hung on the main charge versus the lessers, not separate charges. Okay. I can't say that I'm shocked that Lally cited that then, because he's doing whatever he can to sort of obfuscate the requirements of the prosecution and the court. Can't say I'm even remotely surprised by that. Shit, there was something else that I was going to... Someone asked me to look into something. I cannot for the life of me remember what it was. Why don't you just contact the YouTubers and ask them if they would have a problem with it? Generally, when it's something like that, they're happy to be getting more eyes on it. Oh, no, I agree with you on that. I don't think that's an issue. It's more just... I would have rather been able to see it myself rather than have other people's commentary over the top of it and all that sort of stuff. But, you know, if I've got to. If I've got to, I've got to. It's distinguishable to the case since she didn't inquire at all. Yeah. Check your Twitter DMs. Okay. Okie dokie. Where are we? Oh, X, I should say. X. Bev's jury instructions. That's what it was. You wanted me to go through the jury instructions. Thank you. Oh, and you've already clipped it so it starts exactly when she starts. Excellent. Okay. Well, we can go back to this. Can we not say Bev screwed the pooch? Fair. Oh, that's a flattering screenshot right there, isn't it just?
All right, jurors. Thank you for serving on this jury and for being so attentive. You'll soon deliberate for the purposes of reaching a verdict in this case. But before you do that, it's my responsibility to give you instructions concerning the law. The instructions are divided into 3 parts. The first is general instructions that are provided in every criminal case. The second, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give special attention to any.
Oh, it's not only that, Brandon. The money on this alone. I mean, Karen's how many millions of dollars in the hole on this? And she could have gotten an acquittal. Blows my mind that they do 8 weeks of trial, then rush the instructions and the forms. Yeah. But it would be wrong of me to say that, I don't know, that it was deliberate. But anyway.
Any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You will also get a written copy. I'll probably send in 3 or 4 to the jury so that you can refer to it in the jury room during your deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any...
Wait, what? I will try to make sure that my oral instructions match the written instructions. You should be reading them off the page verbatim. What do you mean you're hoping that they'll match? How did I miss that the first time around? Oh, wait, no, I skipped the jury instructions. That's right, because I was asleep. Shock horror.
difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the...
What? If there's a difference between the written instructions that are provided to you that you take into the jury room and what I say, listen to what I say over what's written in front of you. They're not even allowed to take notes into the jury room. How the hell are they supposed to do that? Because we all skip over that part on the rewatch. Well, to be fair, I skipped like the last week because, you know, shit happened. What? Motherfucker.
The law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. What the lawyers or witnesses may say or suggest about the law is not necessarily the law. That's
Okay, so just for Jill's sake, what they're saying there is that the law is as presented. They can't use their own personal opinions. So, for example, it is my personal opinion that, for example, pot should be regulated as opposed to being a scheduled drug that will see you put behind bars here. So, for example, if this was a trial about possession of marijuana, I would still have to follow the fact that it is illegal under the law, as opposed to my own personal beliefs. Then she says out loud, do not fill out the forms until you're unanimous on all charges. Ooh.
That's because it's my responsibility as the judge and mine alone to instruct you on what the law is. So I now will turn to part one of the instructions, the general instructions that apply to all criminal cases. As I explained to you at the beginning of the trial, there is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution is proved beyond a reasonable doubt through evidence presented during the trial that Ms. Reed committed the crimes charged. I will explain reasonable doubt in just a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. Ms. Reed does not have to testify, call, or question witnesses or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. The burden of proof never...
Sorry, just so that I can make sure that I'm focusing on what she's saying. Jonathan, I did a whole segment on it in last night's show. It's in the time code if you want to go back and watch it. It was hilarious. Yes, but you're not allowed to talk about that. You say those two words anywhere near a jury deliberation room, and you're tossed on your ass.
Shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt.
Yes, they did it at the federal level, so it's across the board, Liverpool.
What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof.
Blue Evero has donated $link and says for your secret double-headed toy.
It's not what you think. I just, as stupid as it is, I want to keep it a secret because I want it to be a surprise, but at the same time, I kind of feel like I'm going to have to reveal what it is just so people actually donate towards it. But thank you, Livaro. Appreciate it.
Proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence.
God, he looks like such a dick.
This is what we mean by proof beyond a reasonable doubt.
Oh my god, I just realized what he reminds me of. And I can't say it on YouTube because it'd get me yeeted. Oh my god. Oh. I gotta remember to say that on a local stream at some stage.
Now, how do you decide whether the Commonwealth has proven each element of an indictment is true beyond a reasonable doubt? Let's talk first about the roles we all have. You folks are the most important people in the courtroom. It all begins and ends with your function. You will determine the facts in this case, and that is your job and your job alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must determine the facts solely and entirely on the evidence as you have heard it and seen it in this courtroom and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion.
Yay, Jill. Thank you.
Jill Ems has donated $link and says happy to add to whatever it is.
Much appreciate it.
Or sympathy, passion, or prejudice. The Commonwealth and Karen Reed have a
Livaro coming in with another one.
Blue Evero has donated $link and says, hey Bev, maybe make the verdict form easier to follow.
That'd be nice. Let's go, Brandon. Also coming in with one.
Let's go. Brandon has donated $link and says you're getting a 2-foot double-sided cork. You going African-style, Dick?
No.
right to have the case judged by fair and impartial
I will say that something is going to get erected. And I'll leave it at that.
jurors. All parties who
Oh, I think that puts us on
court
Doggercam too.
stand as equals before you. Therefore, your verdicts must be based on the law as I've given it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the
Might have
nature
been
of the
Berbers.
crimes with which Ms. Reed has been charged, or the consequences of your verdict. Just the cool, reflective,
Is
and
it a yurt?
impartial sifting of the evidence, so that here in this courtroom, justice may be done. Now, your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in this case. However, I have no opinion about how you decide this case. You should not consider anything I have said or done during the trial as reflecting any opinion by me about how you should decide this case. If you believe that I have an opinion about the facts of this case, you must disregard it. You must decide
Yeah,
this
but-
case based solely
Specifically what, because I didn't know that it was Johnny Sins until I literally just looked it up. But it's what he did. And that's the part that I can't talk about, and that's the part that I can't get out of my head now.
on the evaluation of the evidence. Now, the arguments of the lawyers are not evidence. They are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court's procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They're simply doing their job during a trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for and during the course of the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. Now, the verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, the importance to give any testimony or other evidence.
All right, 1 sec. Sorry. Because we have officially unlocked the doggo cam, the Labracadabradors. Hang on, where is it? No, it's not that one. I don't want to turn off anyone that's new. That's the duck. Damn it.
Who let the dogs out? Woof, woof, woof.
All right, there we go.
Is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits in the case. There are some things you have heard about that have not been introduced into evidence, such as written statements by witnesses, police reports, autopsy, and accident reconstruction reports. Occasionally during the trial, you have heard references to such documents, and you may naturally wonder why neither side introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you view exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed or why. Any information that you may have read, heard, or seen about this case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to questions, and the exhibits are evidence. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in this courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law to that evidence. I have allowed you to take notes during the trial, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with other jurors. Consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Please keep an open mind until then.
You and Angel both, Stinge.
You'll remember that we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable
There we go.
or convincing any part of the evidence is. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case or to the other witnesses or the parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations, and ultimately as to whether or not it impacts the credibility of the witness and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for that purpose. Now, you've heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted tests or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you. And you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. Now, during the trial, I gave you some limiting instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I am going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You have heard evidence about interactions that Ms. Reed had with Mr. O'Keefe and other witnesses in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29th, 2022. You may not consider that evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must also have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored them were, in fact, John O'Keefe, the defendant, or the witnesses who testified about their communication with John O'Keefe and
No, look, don't get me wrong. These are very long, very arduous, very, very verbose, very whatever else you want to call it. But these are all standard jury instructions. The one that stuck out to me so far is she said, well, if I say anything different to what's on your piece of paper, you make sure you listen to me and not the piece of paper. That's some bullshit. The jury instructions are supposed to be standard. But this is just...
or the defendant. If you do not find it is more likely true than not that John O'Keefe,
Do they need to be that long?
Reed, or the witnesses who testified here before you were the persons who authored or transmitted the electronic communications, then you may not consider the electronic communications in deciding the case. Now, the Commonwealth has introduced photographs into evidence. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and
I'd
not
love
one
to see
based on
Borowski on
pity
this.
or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You've heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind.
Hey, Winterstone.
You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's cell phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that the defendant was aware of John O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you reasonably can
they saw
infer
some more
from
stuff
the
than we did,
evidence
Jill.
that she did learn of it. You've also heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you are going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she is alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence that you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witness testimony that I mentioned earlier, including any bias or motive these opinion witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training, and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of these witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the assumed facts.
You notice how she's not even stopping to take a break to let this information sink in? She's like, oh yeah, make sure you listen to all of my instructions. And you notice how, I guarantee it, how to fill out the jury form is going to be one of the last things that she talks about to make sure that it sticks in their brains. I believe this was habeas corpus at this point for the jury.
Are true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part,
I don't think
any
I've ever actually
opinion
seen a
or
judge
conclusion that a
picking a
witness
foreman.
offered during the trial. Now, you have the same powers with respect to the exhibits that you have and the testimony of the witnesses. Look them over and decide the weight. That is the value they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it is written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what the exhibit purports to show and how much weight, if any, you give each exhibit. Now, you've heard me talk about the sources of evidence in this case. Those are the tools that we have to decide the case. Now, with the evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse.
Wait, what? she picked him before they decided on the alternates. So she effectively decided that, hey, you're going to be the foreperson, but if I pull your name out of the hat, you're still going to deliberate? What? Also, thank you to the 102 of you watching, because apparently at least, we're on par. We're 103 viewers for 102 likes. So, but, you know, maybe just double check whether or not you've hit the subscribe button, people, whether or not you're still subbed, whether or not you've hit the like button, whether or not you've, any number, all that sort of things. So...
I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe, because you are entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Circumstantial evidence...
The foreperson was removed from the random jury selection for deliberation after being chosen. That is so inappropriate. So she effectively decided one of the deliberating jurors beforehand. Oh, no.
Exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seems more reasonable to you. Remember, when you are dealing with inferences, you never have to infer anything. You may, but do not.
I saw that he got to the 100K. I didn't realize that they were yeeting 30 to 100 to 200 people. Doesn't shock me, because I've been in purgatory for a good 6-7 months. I've literally been at the 31,700 mark for, what, 6 months now? 7 months? I'm still 8 away from cracking the barrier again. Then Gouveia just dumped 5k people over to just push it over. Damn it. That's what I need. I need to do a subathon and just have a bunch of the other lordships just dump a whole bunch of people across here and just say, hi! But no, they don't know that I exist because I don't invite people on the channel because I feel intimidated and don't have anything to talk to them about. Either that or I get ignored. Anyway. But anyway, I digress. That's just me whinging. And this is not the monthly bitch stream. That's coming up.
Not have to draw any inferences whatsoever. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household, a child, roommate, or spouse...
Oh, yeah, no, Brandon, I do that too. I actually have that on my screen. when I started losing the subs again after I hit 31.7, I decided to turn it off. Here, I'll turn it back on and you can watch it. You can play around with it in real time. Hang on. Actually, do I have it on the dog cam page? You don't suck near as bad as you think. We'll see.
Hands you the mail and states that he or she observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the event with his or her own senses and told you what he or she observed. The issue you would have to decide is whether the witness is credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday.
Okay, apparently in Massachusetts, USA, the judge selects the foreman. Jurors are numbered. In my last court case, the clerk wrote down their numbers on a piece of paper and the judge picked one. The judge did ask the person if they were agreeable to performing the task and the person had the opportunity to decline. So, hang on. Learn about jury selection in Massachusetts. Let's see whether or not I can actually access the... I can access the page! I can access the Massachusetts government page! Usually doesn't let me. Trial jury service... Serve trial juror's handbook. Hello. Will I be paid? Your employer is required by law to compensate you for the first 3 days of jury service, and the Commonwealth will pay you $50 a day from the 4th day onwards. Ouch. Sorry, guys. Does the judge pick before the alternates? That's a good question. I'll continue to play this and have a look.
The letters in the box are postmarked. You have exactly the same power in this case. Not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I have just described. You may have noticed that the defendant did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that the defendant did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. All right, that completes my first part of the instructions.
Oh my god! Also, thank you to the 2 people that subscribed. Bloody hell, Bev. Let's see if commercials are on. They are. They should be, anyway.
Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. Ms. Reed is charged with second-degree murder. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred.
That's fine, Lil Pill, thank you.
The second element is that the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has 3 subparts, which I will call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the 3 prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant
babes, hello.
consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether Mr. O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous.
Okay, sorry, just to settle the debate on it. The rule is fairly straightforward. All it is General Rule Section 68A for the foreperson. Under Section 68A, after a jury has been impaneled and sworn, the court shall appoint a foreperson. So apparently, I mean, oh, hang on, it depends when they're talking about sworn in, whether or not the... Yeah, I mean, the jurors would have to be sworn in at the start of the trial, so theoretically, the court could appoint a foreperson, like, on day one. The jurors are required to render a verdict. Failure of the jury to agree. Oh, hang on. If a jury, after due and thorough deliberation, returns to the verdict without agreeing on a verdict, the court may state anew the evidence or any part of the evidence, explain to them anew law applicable to the case, and send them out for further deliberation. If they return a second time without having agreed on a verdict, they should not be sent out again without their own consent, unless they ask the court for further time. Yeah. And then it goes on to translators for deaf jurors. Yeah, Bev appointed it. I just wanted to know exactly when... we were curious whether or not they were supposed to be appointing a foreman after the alternate jurors were removed, or if it was... well, yeah, I mean, if it was after the alternates were removed. But apparently the court can appoint the foreperson at any time after they're impaneled.
Bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of those elements beyond a reasonable doubt, you must return a verdict of not guilty. The next is manslaughter while operating a motor vehicle under the influence of liquor. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was a 0.08 or greater. You'll have both these choices on the verdict slip. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial...
No, Benjamin, it doesn't. It says sworn in as jurors, which in most cases takes place on, like, the first day.
harm will result to another, and fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. So to prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the well-known things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which, alone or in sequence, will set the vehicle in motion.
As do I, Bush, but I'm waiting for something very
To prove
specific.
the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or
I did,
highway that
Burberry's.
is open to the
I was
public
reading
and
it.
is controlled and maintained by some level of
That was in
government
section
is a
68
public
and
way.
68A.
This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was a 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they've consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to.
Ergo, specifically, I think it's Benjamin that's using the voice to text. If you are driving, you are currently under the influence of Bev's monotonous voice, and therefore should stop watching immediately. Why can the cop drive under the influence, but they want to find her accountable for driving? Because she's the one that's on trial. Because it would be up to the prosecutor to bring the charges. It's bullshit. Also, there's now 115 people watching. If you haven't already, maybe just hit that subscribe button.
To unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or
I don't think she was at
erratic
any
manner,
point.
but it is required to prove that their ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this first theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may...
Actually, it may well have been. Hang on. Sorry, just to answer the question. It was offense 2. They may well have had an issue with the fact that they couldn't prove that her blood alcohol was a level of 0.08 or greater. That might actually be why they were deadlocked. Because the evidence doesn't prove it. Or maybe they felt that enough was shown to show that she would have been intoxicated and therefore they should have. That's actually... manslaughter while operating the vehicle under the influence. So it's literally... That literally could be it. It literally could be. I'm sorry that I'm saying literally, but that's because I know that's a pet peeve for some people. But that was the charge that they were allegedly deadlocked on according to them affidavits. And each one of these is whether or not they were operating a motor vehicle under the influence of alcohol and or operating with a blood alcohol level of 0.08. There is no way in hell they could have said that based on the evidence that was provided in the trial. That could be exactly what it was. Fucking hell. Nope, wrong one.
may also consider whether a blood test showed that the defendant had consumed any alcohol. However, no matter what the reading is, the blood test is not sufficient itself
There weren't
to
any
prove that the
provided.
defendant was under the influence of alcohol. Now, under the second theory, and again, both will be on the verdict slip, and you should decide each one.
Oh, here we go.
The Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was a 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly.
Oh, yeah,
You
when
may
she was
also
sectioned hours later,
consider
yeah.
any other evidence pertaining to the test. Mr. Court Officer, I know it's traditional to not allow anybody in and out of the courtroom while I'm charging, so I'm going to ask you to follow that at this point. Thank you. It's distracting, and I don't want it to be distracting for you folks, okay? The fourth element that the Commonwealth must prove beyond a reasonable doubt is that the...
Hang on.
MLS, Making Laws Simple, has donated $link and says, okay, but lawyer man, if they were ing on 3, then she didn't hit him with a car drunk or sober.
I think you're right. Hang on. Berries. Verdict slip 3. No, there's verdict slip 1. Verdict slip 3. No, because verdict slip 3 does not mention the alcohol. Verdict slip 3 just says leaving the scene of the accident that resulted in death. Oh, I see what you mean. I think that would come down to whether or not she had the guilty mind, the intention behind it to leave the scene of the crime. Because that's not strict liability. That's a case where your actual intention matters. That may be why they decided that, hey, she didn't know that she was leaving the scene of an accident. God, could you imagine if it comes back that the only reason they hadn't acquitted on charge 2 was because they were confused by the alcohol level? They believe she hit him and didn't know she hit him. She can be guilty of 2 and not 3. Yeah. Is this the entire second form? This one is, yeah. Or is there a DUI only charge, like the absolute bottom option there? No. It's literally guilty or lesser charge. Motor vehicle homicide, manslaughter, involuntary manslaughter. I reckon they could have been arguing over whether or not 2 or 3 applied, and whether or not there was enough to prove she was under the influence of alcohol at the time, maybe. This is all entirely speculation. I've got no clue. But, look, Brandon, you do make a good point there. You'd have to be drunk to not realise you ran someone over doing 40 in reverse. Yeah, either that or it would have to be, I don't know, a snowstorm. Offense 3, page 3. Yeah, hang on. I got it here. Open image in new tab. So that's offense 3 there. Hey, Phoenix, how you doing? Why does the friggin' voice... Oh, because that did that through Streamlabs. Just basically going through all the Karen Reed stuff. From the start of the show to now, what you've missed is... I went through the defense's motion to dismiss counts 1 and 3, the second-degree murder, and the fleeing the scene of a vehicle. We then went through. We watched the mistrial declaration. Then we went through the state's opposition to the motion to dismiss, poked a few holes in that, and now we're sort of just listening to the jury instructions so that I can double-check a couple of things. FBI experts said the car played no part in his death. The physical evidence shows he wasn't hit by a car, but it was in a right. Pretty sure when she gives him the second lot of instructions about the second page, she tells him to come to an agreement on one and then go down to the next. Oh, God. This is what I get for missing the jury instructions the first time around.
Defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently. That is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger or death or serious injury to others, but chose, nevertheless, to run the risk and go ahead.
Thank you, Stingy.
Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved the element. Here, the defendant must have intended her acts in the sense that they were not accidental. But it is not necessary that the defendant intended or foresaw the consequences of those acts. As long
I think they said she was doing 24 miles at most in reverse.
as a reasonable person would know that they were so dangerous.
And to be fair, the speedometer showed 24 miles. That's not to say that the wheels might not have skidded on the snow at the time and moved faster than the car actually could have. That's the trouble. We have so many variables in this that it's not funny.
Dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in the category of cases where public safety requires each driver, once they know
No, but it doesn't need to be snowing badly for a car to
determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation.
Because the other guy only knew how to do forward.
The defendant's rate of speed and manner of operation, the defendant's physical condition and how well the defendant could see and could control the vehicle, the condition of the defendant's vehicle, what kind of road it was.
Okay, I get it. But I'm going to take that with the grain of salt that I believe that it deserves, because as someone that previously had a fitness tracking app on my phone, I can say that that thing can definitely be manipulated. But in watching Super Trooper on the direct, I instantly picked up the key cycles not lining up. That 24 miles an hour was likely the car going onto the tow truck. That is true too. Thank you for reminding me of that.
And who else was on the road, what was the time of day, the weather and the condition on the road were, and what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred.
That was my
If the
assumption
Commonwealth has
too.
proven all five elements beyond a reasonable doubt, you shall return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with the lesser included offense. The Commonwealth may prove the lesser included charge of involuntary manslaughter even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. So I will define involuntary manslaughter. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused John O'Keefe's death. Third, that the defendant's conduct was wanton or reckless. I will now discuss each element in more detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another person that a person undertakes with indifference or with disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created
No, it's a
by
real
her
book.
conduct, her subsequent
Screen
act amounts to wanton or reckless.
for anyone that doesn't know, because I use this screen for like reading the news and that sort of thing, so it doesn't look weird when I'm doing it, I have the camera mirrored so that it looks like I'm looking towards the video or whatever screen I'm reading, because otherwise I'd be looking this way. So no, it's a real book. It's just that my screen's mirrored.
Reckless conduct, whether or not a reasonable person would have realized the risk of grave danger.
No, this is my legal
Even
dictionary.
if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew,
No, because then I reckon the
would
Uber
have
driver would be on
realized
trial.
the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined them. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol.
Yeah, but we could select
you
the
may
prosecution
consider
never
such
brought any
evidence
charges
in
against
determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and negligence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle
Okay, she's on the
under
last
the
one of number
influence of
2.
liquor, also charges
And
her
then
with
she's
the
only gotta
lesser
talk about number
included
3.
offense. The Commonwealth may
Thank
prove
God.
the lesser
We're almost
included
there.
charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. So I will define that for you now. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has a right of access.
It was a
Third,
570
that while
SUV.
the defendant was operating the motor vehicle, she was
Oh,
under
yeah,
the
Gabby
influence
Mara
of
got to it first
intoxicating
before me.
liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as I've previously instructed you just moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the fourth element. To prove the fourth element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable
Jason, why
person
weren't you
would
providing,
not act. This
like,
can happen either by doing something that a reasonable
where was your
person
evidence on
would
the
not
stand?
do under the circumstances, or by failing to do something that a reasonable person would do.
You mean like polling a jury as to whether or not they'd reached a verdict before declaring a mistrial? Something a reasonable judge would do? Okay.
Defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that could have avoided, that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or may not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of road it was, and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant.
Jane Mongoose, we read through the affidavits in about the first
is leaving the scene of an accident resulting
half hour
in
of the
death.
show. Hour.
In order to prove the
I'm gonna have to
defendant
do
guilty of
timestamps on
leaving the
this.
scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated on a public way or in a place in which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. And fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed you on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define them any further.
Oh, thank God.
Save a little time for you. Right. As a general rule, you are permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him.
At this point, individuals that I expect to be rooting for Brian Koberger in the chat. Great success. KY. Oh shit, who was the other one that was really annoying last night? I can't remember. Not that I'm putting you guys in the same category. There was someone in Jeff's chat that was just a pain in the ass. But it was very clear that they were just doing it to be a troll, and it was hilarious. Koberger's going to be the Super Bowl of trolls. We'll see what happens. I may or may not block out some time to watch it.
A reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be
Probably look
capable of
into
causing
that case.
serious
Oh
injury or
no,
death
seriously?
to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. Now that completes the second part of my instructions. I will now turn to the final instructions. In order for a jury to return a verdict, that is to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are still 14 of you. To avoid the need for a new trial, if one or more jurors becomes ill or has to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. However, when you begin your deliberations, the law of
Oh, get it off,
Massachusetts is that
Horseface.
there
Come
can
on.
only be 12 jurors. Therefore, at the conclusions of my instruction, the clerk will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted because, as I've indicated, it is important that we have extra jurors in the case of emergency. If we did not impanel extra jurors and a juror became ill or for some other reason had to be excused, we would have to try the case all over again with a new jury. In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start their deliberations
Oh yeah.
all over again from the very
The F
beginning.
counts. Not.
Therefore, it is important that the alternates not discuss the case with anyone, including each
I'm gonna
other.
have to go back through
For
and
if
make
an
sure that
alternate becomes a
everything's
member of
on.
the jury for deliberations, the alternate's views
That's
should be
annoying.
his or her own and not influenced by anyone else. Now, different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own foreperson. In Massachusetts, the judge is responsible for selecting a foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations, however, in that sense is exactly equal with all the jurors. I am going to ask juror in seat number 1, juror number 400. Would you be our foreperson, please, sir? Thank you. When you return to the jury room to deliberate, the court officers will deliver to you all of the exhibits in this case, as well as the verdict slips that you will use in returning your verdict. Your
here we go.
foreperson will be given verdict slips setting forth the charges against the defendant. 12 jurors must agree before you have a decision as to any charge. That means that to find the
That is poor wording. I've just sat through this entire thing for that one sentence. I have just sat through this entire instruction set for that one sentence. The ambiguity of saying any charge. That is what led the jury to believe that they had to be unanimous on all charges before filling out the jury forms. Don't worry, I'm going to replay it. Because I'm sitting here and I'm staring off into space about how ridiculously stupid that is.
exhibits in this case, as well as the verdict slips that you will use in returning your verdict. Your foreperson will be given verdict slips setting forth the charges against the defendant. 12 jurors must agree before you have a decision as to any charge.
Twelve jurors must have a decision, must agree before you have a decision as to any charge. That is so fucking poorly worded. look, it may be just Stacey, but it may not be. The problem is that at the start of it, she said, hey, if I say something that is different to what's on the instruction forms, you listen to me as opposed to what's written there. So, pretty sure it gets better.
That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should continue deliberating until you have reached a final verdict on each charge. You should not be...
Well, yeah, no, they are supposed to deliberate until they reach a final verdict on each charge, but that... Oh, shit, no, even that's poorly worded. One word fucks it all up. Well, see, the trouble is I don't have a copy of the jury instructions. And specifically, again, because she's overrided the jury instructions with what she said, we have to go purely on the wording. And I would argue that she done fucked up. Bev done fucked up.
Begin deliberating until all 12 jurors are together in the jury room and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case.
And as a result of that, that adds the further dispute with the jurors. Hey, we're not sure if we're allowed to talk about this. We're not even sure if we're supposed to mention it to the judge.
Further, I instruct you that no juror is better qualified to determine the truth of the facts in dispute or to deliberate on a verdict solely because of education, background,
There may be,
or
let's go.
experience.
I don't have access to it.
The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong, but no juror should...
And I should be clear here as well. She is reading, but she is reading verbatim off of something that she herself has prepared. It was the same thing with the Tui Rodriguez instructions. She has her own that she wrote out herself and read out. It's not verbatim what the instruction is according to the court precedents. She's reading out something here that she's prepared herself. And because of the way that she phrased that, it led at least 4 jurors to allege that they didn't realize they were allowed to say that she was not guilty on murder and leaving the scene of a crime.
Surrender an honest conviction to the opinion of fellow jurors simply for the purpose of returning a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin conducting an immediate straw vote. Rather, I encourage you not to take any votes until you have completed a careful and thorough collective view of all the evidence.
Oh, fuck that! Can you honestly tell me the first thing when you walk into the jury room isn't going to be, so who thinks she's guilty? You know? Like... I was under the impression that the original instructions was something that they use in every trial. They're supposed to. There's supposed to be ones that get used, and that's what's really irritated me about this. Is that she's reading out ones that are not, and it's not even that she provides the copy that she's got there to them. That's reversible error. No, if they all agree on the instruction and he freebases it. I don't think so. She interfered with the jury's decision due to her poorly written instructions. Look, it'd be a stretch for me to say that I think that it was written deliberately vague. Could she be held accountable for not giving clear instructions? Probably not, because they'll just say it was vague. It wasn't intentional. It wasn't, it was an unfortunate accident, but accidents happen.
At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national.
Look, possibly KY, which is why there's the extra malfeasance of her jumping straight from reading that note into declaring a mistrial. She's blonde. That's not her real hair color, let's be honest.
National origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations
There
and
he is.
assumptions,
We missed a
even
great
if
success.
we're not consciously aware of them. And I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as a member of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions. So don't
I don't
be shy
think so,
or
KY,
hesitate to speak
but
up.
I still genuinely
You should
believe that the whole
participate
having
actively,
conversation with
particularly
the
if you think the other jurors are
counsel was
overlooking
important.
or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible. That is your responsibility as jurors. Now,
which they allegedly
during
did.
the course of your deliberations, you might have a question concerning the law in this case. I'm not suggesting that you will, but you might. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officer. Because your role as the jury is to determine the facts of the case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible to provide you with a transcript of the testimony, even though we've had a phenomenal court reporter throughout this whole trial. If you send a question to me, I will respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case.
Wait, what?
Question to me, I will respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. We will not answer a question or take a verdict between 1 and 2. You'll have lunch brought into you and decide whether you want to stop your deliberations during lunch or deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return tomorrow morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before such time as you have reached a unanimous verdict.
And there's the other one. Don't inform her until such time as you've reached a unanimous verdict. Well, allegedly they reached a unanimous verdict on 1 and 3, but they did not believe that they could provide it to her because of the way that she'd phrased the other jury instructions. So she tells them they can't communicate where they're at. Yeah, and if they have any questions, it has to go through the foreperson that she just chose. Which could mean nothing. It could just be randomly chosen that he was the foreperson, but, you know.
You are going to notice shortly that the court officers are going to take an oath, and you will hear from that that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict slips and notify the court officer that you have reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts to the court. I'm going to see counsel before we reduce your number to 12.
That's a mess. Now, there's one last thing that I want to see. Don't care quite so much about them pulling the
So, Mr. Clerk, will you choose the alternates, please?
Could the juror sitting in seat number 3, who is juror 79, step down and take your place as an alternate? And the juror sitting in seat number 2, juror 14.
All right. So, ladies and gentlemen, we need to swear in the court officers. They're going to be in charge of you during your deliberations. I suggest that you listen to the oath that they are taking so that you can be aware of their responsibilities. Now you can swear them, Mr. Clerk.
You swear that you will keep this jury and alternates in some separate but convenient place until they agree, that you not suffer any person to speak to them, nor speak to them yourselves, nor ask them if they are agreed, nor suffer them to disperse until they're discharged of their verdict, except by further order of the court, so help you God. Thank you.
All right. So, jurors, I need...
Okay, so I didn't see anything there, but a little birdie told me that one of the officers that was there with the jury may or may not have been Officer Fanning. I was wondering whether or not they were going to name them. So what I understand from all that is for them to not complete the forms until they've agreed on all the charges is a very reasonable interpretation of what she said. She done fucked up. So the friend who was a first responder that didn't come to the house, was he an Albert or McCabe? And did he say why he didn't come out? He was an Albert, wasn't it? That was Brian Albert's place. And she is. Officer Fanning is a police officer who's involved in the investigations in the... Pretty sure he's involved in the Birchmore, but he's definitely involved in the Root case. Don't complete any of the forms until you're totally done. Don't report any of the votes. Yeah.
Need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice, or
Yeah, we do that
sympathy,
deliberately. Great success.
and
My daughter's not great at
prompted by
drawing
any
things.
facts except those that you have heard here in the court during trial. We are looking for impartial judgment dictated by your reasoning and the fullest discharge of your oaths as jurors. You may now retire and deliberate your verdict.
Jurors, this time taking your notebooks. All rise, follow me. All rise. You may be seated.
All right. So, counsel, I'll give you a few minutes to work with Mr. McDermott on the verdict slip, and then I'll come back out.
Thank you, Your Honor.
All rise for the court, please.
That's Buchanan. Oh, that's Fanning there. Okay, never mind.
So
It was a bit at the beginning and a bit at the end that I think was super important as to why this mess exists. Yes, and I wholeheartedly agree with you on that. Pretty much everything in the in-between was your standard sort of jury instructions. The fact that at the start she said, you're going to receive a written set of jury instructions, but what I say to you now may be different, and I want you to follow what I say to you, not what's written on there. And the trouble is that without having that piece of paper in front of them, they don't know what's different and what's not to take notes anyway. So how the hell are they supposed to follow? Except that at the start and at the end, there were two very important things that were put in there. And effectively, a very reasonable interpretation of those instructions are: do not write on the verdict forms until you have a unanimous decision on all verdicts, on all counts. Now, as I said, Bev can claim that it was just vague wording, that there's no issues there, that it's not problematic in any way, shape, or form. I would disagree. Who do you call when you have questions like that? Wait until we do an episode of Kinky Corner on locals and you'll be fine. I think I'm about as qualified as Dr. Ruth at this stage. We've all watched this. One word fucked everything up. Yep. Quite literally. And there was a much clearer way that they could have worded that. Because instead of saying any charges, they could have just said on each individual charge. They could have phrased it in any number of ways. But because she had to go and write her own instructions, or at the very least misinterpret, in my personal opinion, the way those instructions are supposed to be, we wound up with a jury that did not provide partial instructions. Which sucks. And for those of you that are coming in, why that's a big deal for me is because Criminal Procedure Rules 27 for the verdict, which basically says that the judge may declare a mistrial as to any charges upon which a jury cannot agree for a verdict, provided, however, that the jury may first require the jury to return verdicts on those charges, upon which the jury can agree and direct that such verdicts be received and recorded. Instead of doing that, she jumped straight from reading the note into a mistrial, didn't ask the jurors whether or not they'd reached a verdict on anyone, and yes, while this specific rule here says that they may require it, when you come down to the actual notes that include the federal criminal rules and the Accord on Criminal Procedure, subdivision permits a jury in multiple defendant or multiple offense cases with the consent of the court to return a verdict on at any time during their deliberations with respect to charges or defendants as to which a verdict has been reached. As far as I'm concerned, it should be a very clear instruction. If at any time you reach a verdict on any one of the offences, send us a note and return the jury slip. Plain and simple. In either case, if the court directs the jury is to continue its deliberations, to the extent that this rule permits the jury to return such verdicts without having reached a decision on all charges of the defendants is consistent with the federal rules. The rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. The court must first receive and record the verdicts the jury can agree upon. Prior to her saying those words, your deliberations are at an end. I'm declaring a mistrial. One simple sentence should have come out of her mouth, in my humble opinion. Did you manage to reach a verdict on any of the charges? And this whole mess could have been avoided. Really freaking straight and simple. So, anyway, it is now 1:20 in the morning. Given that I had such a late night last night, I'm going to send you all on your merry way. I'll send you all across to... Alright. Quick poll in chat. 1 for Flux, 2 for Lawyer You Know. And then I'll send everybody across to wherever. She can just do nothing, right? There's nothing that can force her to make it right. I genuinely believe that they should subpoena the jury, because there's a thing that says that they can't make inquiries into the deliberation process, But that's not the same as making an inquiry about a verdict that's already been reached. You're not asking about the deliberation process. You're asking about whether or not a verdict was reached. That's not the same thing, in my humble opinion. Sorry, up late again. I'm super grateful for this. No, I wanted to get through this as well. So, everyone saying Flux? Okay, all right. I'm sure she'll be super excited to see 110 people drop in. So, I just really hope she's not getting ready to finish, because she's been going since... Oh, actually, she might be getting ready to finish. Hang on. Hang on. Okay, just give me 2 seconds. How long?
Trial key. Found a trial key.
Going.
All right.
Oops, just did that with all caps. Did not mean to do that.
Oh.
All right. So anyway, guys.
I got an.
Hopefully, she'll see the message sooner.
I
rather
don't
than later.
remember what I had. I think I got a netherite helmet. I don't know if I was already wearing that and didn't put it on. What? Look at wind charge. Is that like for?
Let's
what
read
is
the
a
damn
wind
chat.
Charge?
I should be back in about 9 hours.
Oh, so it's just a loot.
And
thing.
we'll do a just random news stream tomorrow night. I'm still hoping to do the update of the brute case. There are hours of evidence and documents and stuff for me to go through.
Happening?
So I'll do my absolute best.
How long you still going for? What's up, Ozzy? We're not gonna be going much longer. We're gonna be wrapping it up here probably in the next, 10 minutes or so.
Okay, you heard it, chat.
Don't raid! We're gonna be wrapping it up!
Okay,
Love you,
just saying
though.
don't raid.
Thank you!
Alright.
But we're gonna be wrapping it up soon. We just found some new stuff in Minecraft, which is holy cow.
At some point, I do need to go back to vanilla Minecraft. I'm playing the, dragon thing with the daughter.
I gotta figure out this trial stuff.
Alright, that's fine. I will send everyone across to Lawyer, then hopefully he's going to go a little bit longer than that, so... go make some noise, let people know that you are Aussie fans, and that I exist, so... But, shut up, KY. But that was funny. Anyway, as always, people, stay healthy... Oh, no, hang on, let me do this properly. Oh, god damn it, none of the buttons are gonna work. That's what Flock said. Okay, that was bad. Never mind. I'm really gonna have to fix this up. I'm really annoyed that this messed up. I really am. It didn't even do my transitions properly. Ooh, I'm not gonna make the joke. Anyway, as always, people, remember, you're not a piece of shit. You have value and you do contribute to society. And thank you so much for being here. And thank you so much to everyone that donated, gave memberships. Hit that like button or the subscribe button, because God knows I'm 3 away from cracking the 700 mark again. But as always, people, stay healthy, wealthy, and wise. And I will catch you all on the flip side. Now, hopefully the credits work. I don't know if they will or won't. If they don't, I'm just going to skip straight to the ending. And we'll go from there. Cheers, peeps.
This shit, I'm out. Fuck this shit, I'm out. No thanks. Don't mind me. I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out. Nope. Fuck this shit, I'm out. Alright then. I don't know what the fuck just happened, but I don't really care. I'ma get the fuck up out of here. Fuck this shit, I'm